Item one.
Mr. Bhuya?
Not item one. I get the instruction that the petition has been expired before 2 years in a road.
Oh, acha.
In a road.
Mr. L. Bhuya for the petitioner. Mr. Siddharth S.S. Mahapatra AC for the state. The learned counsel for the petitioner submits that during pendency of the petition, unfortunately, the petitioner passed away about in the year 2021.
Before 2 years, my lord.
About in the year 2021.
Yes.
2 years means?
Yes, my lord.
As per instructions received from the legal heirs of the petition.
From the,
in such view of the matter, the petition stands disposed of. In view of such development.
item two.
Yes.
To my lords, 4 weeks time may be granted.
Your name, sir?
S.E. Haq.
Mr. S.E.
Haq.
Syed Inamul Haq.
Syed Ijazul Haq.
Ijazul Haq. Okay. Mr. S.E. Haq on behalf of Mr. S.S. Rao for the petitioner. Mr. S.S. Mahapatra, additional standing counsel for the state. Instructions and advance arguments as prayed for list on 4 weeks पर देवे तमने vacation पर पड़ेगा 5/1 5th of January 2024. Yes.
Item three.
Someone was mentioning.
Yes.
पड़ेले बुझुनांति ना कौन कहले to be called again. 4. Mr.
May I please your lordship?
State.
Petitioner counsel in item number 3 probably died, my lord. Dharanthara Jena.
हाँ he would mention कोटा कोटले 4 ना 3 mention कोटले
4
कोटा कोटले.
Yes.
No. 4 is mine.
कोटा तो के ना
5 टा mention करथिले man not press हला 5
डिप्पी दास तो कहले ने आउ जने mention डिप्पी दास को जब कोरे जने younger person he was mentioning one matter. I said कि just wait. 3 he mention करथि. Yes, he has noted. पढ़े लेन कोडे डिप्पी काई हो
12:30
2 टा
आगे
item 2 टा करथिले
2 टा करथिले आपण वेट
तो
करिया
से थिले 2 टा मेंशन हैला से एसएस राव को मैटर से
से फर्स्ट मेंशन
ठीक है जल्दी 3 टू बी कॉल्ड अगेन
मान
से एमके दास तो थिबे ना धरन जना को चैम्बर.
Yes, my lord. He must be there, but virtually in fact matter became infructuous, my lord. He was challenging the order of framing charge of case of 2012. No
stay order.
No interim order is there, my lord. As it appears from our record, my lord, that must have been concluded.
अच्छा.
Case diary is available.
Interim order is there.
Interim order is there, my lord. But in view of the Asian
resurfacing, 2 orders after that.
Last it was listed, my lord,
in 2013. 10 years back.
So yes.
Petitioner
on merit also it doesn't because I have the case diary, my lord, challenging the framing of charge. There is having prima facie case 376, 354 case. Other offences are
none appears for the petitioner when the matter is called. None had appeared when the matter was last taken up on 12/10/2023, and to grant further opportunity, the matter was adjourned. The petitioner had challenged the order taking cognizance, order of framing charge. Framing charge dated so and so, passed by so and so.
Dated 15/12/2011, my lord.
The interim order was last extended by order dated 27/8/2013. Thereafter, the matter has not been taken up. Oblique listed. After since no up-to-date instruction is coming from the petitioner regarding the present status of the case, the petition stands disposed of. If it is possible, they want to revive, they can revive. So that is how I am not expressing any opinion further.
Item 4.
The interim order passed directing stay of the further proceeding. See, Rajo Kalen interim order. City add kar debe, insert kar diyantu. Directing stay of the further proceeding in the before the learned trial court.
And this this order may be communicated to the learned court.
The last elective, the order be communicated to the learned court in season of the matter. Mr. Das, please.
My lords, am I audible to?
Yes, please. Yes.
My lords, item 4 can be disposed of now, my lord. If lordship permits, my lord, in a case of trap, in case of trap, the accused, who is the opposite party in this case, was let off. And because the allegation is that if lordship turn to page 2 of the judgment, page 2 of the judgment, paragraph 2, my lords.
Yes.
Page 2 of the input judgment, paragraph 2, the last portion, my lords, it indicates the complainant against his will agreed to pay 300 rupees as bribe to the accused with a hope for preparation of other pending TA and medicine bill, and the date was fixed on 25/8/2010. This was the allegation of demand of 300 rupees for clearing all the TA bill and the medicine bill. Lordship can turn to the findings. Page 20 of the paragraph 14, Lords. Lordship turn to paragraph 14. The last portion starts. Paragraph 14, last portion. It starts in the present case as discussed in the preceding paragraph that demand of bribe by the accused and the acceptance of bribe by the accused from the complaint decoy has not been proved by any independent witness, and the evidence of the complaint decoy doesn't create confidence as the same is unreliable and not trustworthy. The 30% area of bills was prepared by the accused on 22/8/2010 as it reveals from the above in the complaint petition. The complaint himself has PW. So here the decoy is PW3 and PW4 is the shadow witness. And about the shadow witness PW4, the shadow witness has not seen the demand and acceptance of the bribe money accused. And thereafter, Lords, the plea of the complainant was that if Lords skip the next line, it starts from the explanation of the accused that the complainant forcibly inserted the bribe.
Thank you.
I'm kindly 1 minute. I'm placing the evidence of PW4, the shadow witness. Lords,
so actually, by the date, the demand, Mr. Das.
I'm not arguing for.
Yes, I understand, sir. I understand. So just kindly listen. By the date the demand was sought to be made, all the bills were passed, cleared.
That is one thing. And secondly, my lords, the statements of the decoy has not been supported by another witness, another eyewitness, that is the shadow witness. This is the findings of the London Trial Court. And I'm placing just one line statements of
assuming Mr. Das, everything is proved. But the prosecution fails to prove that there could have been any demand for the satisfaction of the person.
No. Demand of the accused that the decoy was there, but it's not being corroborated by the shadow witness. I'm placing one line.
Other problem here is that the motive of demanding the bribe is to clear a 30% arrear bill and medical bills. So by the time the bribe was presented, nothing was there to be done.
And my lord, that's why, my lord, to support your lordship views, my lords, I am placing the one line of the PW4. I remain outside that room on the veranda.
Yes.
So for that reason, my lords, the trustworthiness of this particular witness was put in the doubt, my lord, by the London Trial Court. Both the person went inside that in the date of trap. My lords, we stopped the vehicle at little distance from the block office, where for myself and the decoy proceeded to the block office.
PW4 says that neither he has seen demand nor he has acceptance.
Now his statement is that while I remained outside that room on the veranda.
Page 12 of the internal page 12 of the judgment.
My lords, you can dispose this.
4th line from the top.
My lords.
The leave petition has been filed by the petitioner, so and so department likhibe. The leave petition has been filed under so and so section of the CRPC by the petitioner state challenging the judgment and order passed by the learned so and so in so and so. The learned court had returned a finding of acquittal against the opposite party against the allegation of various section of the Prevention of Corruption Act 1988. The learned court has relied on the prosecution evidence as presented to give a finding that the requirement of the illegal demand, the basis of illegal demand, that is passing of 30% arrear pay bill, and the medicine bill for reimbursement were proved to have been prepared on 30/11/2010. The pay bill was prepared on 28/8. The pay bill was prepared on 22/8/2010, placed before the head clerk. That was before the trap was laid by the prosecution on 25/8/2010. In fact, it was passed by 30/10/2010. Such a finding has been given on the basis of cross-examination of the PW9 and the IO PW6. It is for the found that relying on the evidence of PW4 and PW8 as well as PW3, the complainant himself, the demand of the money and handing over of the same to the opposite party was not proved as it was sought to be before the learned court. In view of the above categorical findings, in considered opinion of this court, in the facts and circumstances of the present case, no leave can be granted for appeal. Accordingly, the petition stands disposed of. Yes.
Item 5.
Mr. D.P. Das for the petitioner. D.P. Das for the petitioner. Mr. S.S. Mahapatra, AC for the state. Learned counsel for the petitioners files a memo. Memo dated 2011-2023, stating the instructions received from the petitioner that the petitioner doesn't want to press the petition. Accordingly, the petition stands disposed of. Accordingly, the petition stands disposed of. Yes, next.
Item 6.
Mr. Misra?
Item 6, not safe.
Yes.
This is an appeal of acquittal against in the matter of under section 138 NI Act, Lordship.
Against acquittal?
Against acquittal.
So, please, I have been discussing all this with the bar. Maybe I don't know whether I remember if I discussed with you. You make out from which evidence the lauded court erred in arriving at a conclusion of acquittal. Say jo jahan bhi 138 essential ingredients are there,
my lord.
So where the lauded court, erred in rejecting the that allegation.
The learned court has passed and peculiar order.
So you see, the problem is that 138 is not simple demanding and issuance of a check, my lord.
No, my lord.
Recently, since I have been discussing on the same date, maybe there is a High Court decision now. I don't know what is the basis. That even if it is signed, that is enough, my lord. But you have to prove that demand, the notice, issuance of check by the person, and on the date of, and also the date. So what was the missing link in your case? Because you are for the complainant. Yes.
The missing link was, my lord, the check was issued by the accused. It was presented within the stipulated period of 3 months. It was dishonored. Subsequently, I issued advocate notice. He received it. After 15 days, he did not turn to make the payment, for which I was compelled to file this case under Section 130 NI Act. My lord, in the advocate notice also,
Sir, don't narrate the story. Then we are not discussing in a court, sir.
No,
This is not a drawing room discussion. You please refer to that part of the judgment, my earnest request,
Your Lordship,
where you say the court went wrong.
the court went
This is
wrong.
not a drawing room discussion that you have a genuine. In fact, I have all sympathies for whatever you are saying. But as far the courtroom deliberation, you have to present a case where the learned court of jurisdiction. Only option is that you say the court did not have jurisdiction. Then I have to examine that without going into the
Your
merits.
Lordship may come to page 5, Your Lordship.
No, don't bring me to any page. You say straight away what is your argument that by what the court made the erred, or there is a prima facie.
He
Error.
rejected my complaint petition on the ground that I am not the proprietor of the Taj suppliers for who was the complainant in the case. He never went into the matter under Section 130 NI.
Obviously, for any negotiable instrument act, there is a drawee, there is a issuing person. It has to be.
No,
Suppose you draw a check in favor of Mr. Mahapatra. I present that. Can I bring home a case in 138?
No,
That's the short point.
the accused did not dispute me as not the
Sir, it's not a question of disputing.
my lord.
You have to make out a case. There is always presumption of innocence in 138 also.
No, only ground of rejection was that I am not the proprietor
Then
of.
how it can be? That's the sole basis of the. You see how any court, much less a high court,
Well,
how any court can blame somebody. I gave you example. You issue a check in favor of Mr. Mahapatra. I present it, and it is dishonored. Mr. Mahapatra doesn't know whether it was presented or not. Can it bring home a case in 138? Unless Mr. Mahapatra says yes, I gave to so and so. He went to the bank and he deposited.
My prayer is the accused did not dispute in this evidence or in the
That's not a
examination that I am not the.
Sir, this is not a civil suit. You are trying to bring home a criminal liability of a particular person. You have to show to the court that you are the person intended to be presented the negotiable instrument. Whenever you are having any checkbook,
My lord.
what is written in the bottom? Pay to the blank.
Blank.
Yes, blank. Suppose you write some corporation. Is it the corporation account or the person account?
Person account.
Person account. What was written in your check?
Paras Commercial Corporation. So, example, it's a corporation.
Then I even without going into that, you are answering that. If you are not the intended payee, you have to show that you are the payee, that there was existing liability of the person who has issued the check to pay you. That's it. And somehow I find a very interesting approach as far as 130 is concerned. Somebody is saying that he signed and I have filled up the amount and the date, still he is liable.
I filled up the date. Yes, that's also happened. Yes, also, yes.
Then how a person knows that when, because tendering blank checks are illegal. Tendering blank checks or coercing somebody like a bank loan, always they take blank check. That's a safety measure, fine. But blank check, where you bring in that NDPS, I'm saying, that Negotiable Instrument Act. Have you marked that word? It is said issued. It doesn't say signed. Why then issue is issued is because issue means it has to contain everything.
Everything.
Why you put two signatures behind a check?
To verify the authenticity of the.
No. That's the problem. It's a technical thing. It is the endorsee.
Oh, endorsing. I've seen that.
Endorsee who receives the check, he puts his signature. At times when you are drawing a self check, you are drawing two signatures. Why two signatures? Why?
No idea.
Please think about it, sir.
Why two say?
Who else will know? One signature for presenting and one signature for receiving. But to cut it short, so they are taking two signatures at a time. When even you present a check in a teller or a counter, first they give you a token. So that is the presentation part.
And subsequently,
Yes. And when you receive at the cash at the counter, you are receiving that.
the second part, I got it.
As a student, there was a difficulty because these checks were taken away during post. At that time, 30 years back, there was no this banking online transaction. So we used to discuss what can be done.
No, Lord, that's it. Why the two sides?
Because that somebody opening the packet has taken away the check sent by the father or the parents to the student. So he will put two signatures and deposit it if it is a blank check. I mean, one has to understand this also. Suppose he proves that you never presented the check, then why I'm asking, why I'm discussing that? I'm not asking. The obvious reason is that you have to show that yes, I presented the check.
The said check.
Who part se deal korchon seta je apana nuhanti boli? You are not the intended payee. Endorsee.
Page 5 last part, the complainant
Again?
Siraj Khan claimed in his affidavit to
Taj supplier, complainant Siraj Khan claimed in his affidavit to be the proprietor of farm, namely Taj supplier. I'm reading page 5, para 7, last word, the complainant, 5 lines.
but submitted no document, single document in this regard.
Then,
Mayor mentioning in affidavit petition as the proprietor of the farm, namely Taj suppliers, the complainant cannot create impression in the mind of the court.
it is a proprietorship farm.
My lord.
Then, the way you are arguing, then you can also be the proprietor. Anyone can, any Tom, Dick and Harry can come and say that, yes, I am the proprietor of so-and-so Taj supplier.
My only prayer before.
Then you are really inviting trouble.
That was informed wrong that's a lower court. The advocate has not filed the same. But since my
Sir,
prayer is all
sir,
the
don't blame any lawyer. Whatever material was there,
all the ingredients of the
see, any case after it is disposed of, always can be better argued. That's the only constant factor in any matter. Any matter.
But
The strategy could have been different. The arguments could have been different. The evidence could have been different in any matter, any case. But can it be that a ground for considering or reconsidering the matter? Obviously, the static thing is that you have to, whatever is there on record, whatever was presented, then it gives a finding. Farm, namely Taj supplier, the complainant cannot create impression in the mind of the court that he is the same person that is complainant as well as the proprietor of the farm, unless and until supported by relevant document.
my lord.
To challenge this finding, you have to show that these are the documents presented. Straight away, you have to satisfy the court or bring that ground in the petition. कौन करिवे कुहतु ठीक अछि आउतरे हो. So basically these things you have to discuss when the person brings a case to you. Setire tara problem question je if the lawyer gives a skeptical view, then there's difficulty that he may take out the brief. But the problem is by that is he getting anything? So he must know where he stands. Any litigant must know where he stands. Proprietor se farm ro Taj supplier ro se tankara kon kagaz deitile je dei nothile tanko choice re deitile na apon advice re deitile. Obviously it is his choice. What a lawyer can do. Then how to differentiate between the proprietor and the farm? I mean the actual proprietor and the farm. It has to be a farm because farm has an account. In banking parlance, there is a separate account. It was not credited. It was not supposed to be credited to the individual current account or service bank account of that person. Siraj Khan might be having 10 accounts. If it would have been mentioned Siraj Khan, then it would have been deposited in that account.
In the account, yeah, my lord.
The learned counsel for the petitioner, after advancing some arguments regarding the grounds of challenge, in view of the categorical finding given by the learned court that the complainant did not produce a single document to prove that he was in fact the proprietor of the firm. Quote, Taj Suppliers, unquote. 6 for the time, comma 6 for the time. As paid for. When do you want, sir?
Lord, first week of December.
December. December date कर दियो ना. First week नहीं पारे जब आपको कुछ. 18th December. And there is a clear distinction now if you file annexer and all that in read petition, and as far as the appeal is concerned, or revision. This court cannot take note of that actually. Yes.
May I pledge your lordship? Lordship,
Yes,
am I audible to your lordship?
Yes, please. Yes.
Item 7 of the 2019. Let
Yes.
it come in a regular in a routine course. My lord. Why say so, my lords? I have prepared a list of cases of 2003, 4, and 5. I am praying for lordship, my lord. These 35 cases of 2003, 4, and 5, which can be disposed of, my lord. Those things should be listed on priority basis, my lord. In lieu of this 2019, where these people, after getting acquittal order being reinstated, they are getting salaries. But the people who are involved in 2003, 4, and 5, my lord, in the widows are not getting anything, my lords. That's why, my lord, this item number 7 will be taken up in a regular way, my lords, in routine way, my lord.
No,
Agenda-
actually, since it is a fresh matter, it has been listed.
No, let it come, my
Yeah,
lords, and so on.
yes, after
In
some
the
time,
month of
Mr.
Lord,
Gangaram Das,
Lord,
standing counsel for the petitioner, state.
listed in the month of February,
Learned
my
counsel
lords.
for the petitioner seeks accommodation to advance arguments. As spread for list in January or December?
February, my lords.
January कर दियो. January कर दियो. Last term.
And I may be permitted to submit these 3 lists, my lords, of 2003 CRLP, 2004 CRLP, 2005 lords. These are old matters, lords,
On
for admission.
sorry, on 5th of February 2024.
My lords.
Item 8.
Item 8, my lord. The state has filed this slip to appeal
Yes.
against the order of acquittal of the accused persons, my lord, who were charged under section.
It is a 21 matter.
Yes, my lord.
If you apply what Mr. Das says that old matters are pending.
Fresh admission.
So what is the evidence?
Evidence, my lord, PW8 is the IO and other witnesses, official witnesses, they have proved. The seizure was made in from the petitioners with their conscious possession. Petitioners, the opposite parties, my lord, are their father and son. And another accused, my lord, the wife of the petitioner number 1. From their house, it was seized, and while the petitioner number 1 and 2 were carrying bag with towards the outside of the house.
How is Bhimosen related to Sumati?
My lord?
Sumati, you presented no evidence.
Sumati,
So
my lord,
Bhimosen and Sumati, how they are related?
husband and wife, my lord.
Then how she comes into picture?
My lord,
She was also an accused.
because it was seized from their house. For that, my lord, she was made accused of this case. But in fact, while the petition, the opposite part number 1 and 2 were carrying the bag, it is the evidence, my lord, while towards the outside of the house, they were caught hold by the police, and with their conscious possession, it was
42, 1 and 2, 50 and 57 have not been complied.
that is their, my lord, the stand of the land court below, and the defense. That is
for satisfaction of 42, 1 and 2,
my lord.
what was the evidence presented?
Evidence, my lord, PW8 clearly says, my lord, it was seized and from their conscious possession, and it was. But there appears, my lord, some.
Because para 14 kindly mark. Para
Yes, my
14.
lord, I am holding that one.
There is no evidence against the accused Sumati Sahu that alleged the contraband article was recovered from her possession.
My lord.
No evidence is laid either on behalf of the prosecution that she was present in her house.
Sumati is, my lord, that is, I also concede, my lord, that there no such evidence with regard to implicate the opposite partner 3 is there. But petitioner number opposite partner 1 and 2, the father and son, from their conscious person, bag was recovered and they were holding the bag. This is the evidence.
The PW3 6,
So-
they did not support PW8.
That is PW8 says I had not written it down. When that is contradicting by the defense, to that extent it was not written down as required under section 50 of the NDPS Act to write down the contents of the information received.
ମୋ ପାଖରେ
And
ଅଛି deposition copy ଅଛି.
deposition copies, my lord. Yes, my
No.
lord, that is there. Yes,
So you examine the deposition copy.
my lord. I'll.
What would be the consequence of other PWs not supporting PW8?
My lord, independent.
The problem is that if in cross-examination they have contradicted PW8, then how do you get over that?
No, there are two types of evidence. One is either supporting or contradicting. That is when they are not supporting, they are the independent witnesses, my lord, only declared hostile. Well, that will not, because there is settled decision. Prosecution will not fail.
Yeah, whether they have
Merely
been,
because independent
whether
witnesses.
they have been declared hostile, you
My
examine that. Whether
My
they have been cross-examined also.
Yes, madam.
So to what extent the contradiction affects PW8's version?
No, so one thing,
Because-
what I find, that is the defect in the investigation, that is in writing down the information he received and proceeded. Well, that is the provision. After receiving the information, he has to write it down and then he has to send it to the officer and then to proceed. Well, that is there, but that is not fatal. I come across a decision, I could not remember properly, my lord. I'll cite that. That is not absolutely a fatal to the prosecution case. That will not be at all fatal when there is other clinching evidence to implicate the accused persons. And also here it is the clear case there where it was recovered from the possession of the opposite partner 102. That has not been demolished. The PW8 is the officer who seized. My lord, he was put to cross-examination at length. Nothing was demolished, my lord. He had not seized the, and also there are endorsements of the accused persons.
Page 8 sub para dekhile. Page 8,
My lord,
running page was 17.
my lord.
Internal page 8 of the judgment.
Judgment, my lord.
Yes, judgment, internal page 8.
8, internal page 8. I am holding.
Top of that, I think it is written 17.
She has proved.
It reads during cross-examination.
Yes, my lord. During cross-examination, it is elicited by the law defense counsel that witnesses did not prepare any source memo. That is the, my lord.
This means a PW8.
Yes, my lord. That is the.
No,
with regard
problem is
to-
that PW8 evidence has been somewhat demolished by the
No, that
defense.
is, my lord. My submission.
I'm sorry, other than PW8.
Yes, my lord.
So the
Other than-
only sole surviving witness is
yes.
PW8.
So when he has no hostile relation, my lord, hostile
No, it's a technical
enmity
thing.
or something with
No,
the
it's
accused
a
person.
technical thing. So if it is a requirement of the statute,
Yes, my lord. That
and
is
she consciously says that I have not prepared, then what the court can do?
yes. That is there. My
You
lord.
examine that.
I will examine. On that again.
Because Mr. Mishra has taken, the Taj supplier.
Right.
That is a hopeless case.
Yes, my lord.
He doesn't prove that he's the proprietor and comes here and files a appeal.
No.
Here at least there is some arguable point you have. So you take time also.
My lord.
Then it says, did not prepare any search memo.
My lord.
She did not give separate option to either of the accused persons, whether he wants to seize search in person before a magistrate.
That option is required, but
No, this is ingrained in the statute
yes.
purposefully by the legislature. There is nothing judicial in that because
Yes, my lord. My submission
obviously
is,
because then the problem is that see, this possession is such a, this has a what you call, this is a penal consequence.
Well.
Enough possession is enough.
No, that is
So that
there.
is how
That
this
is there,
safeguard in the statute. So can a court look the other way? When this is brought to the notice of the court, can a court, and the difficulty is that he's the only witness. She's the, rather she, here she is the
Yes,
lady
my lord,
officer.
he is the only.
She is the only witness because others are not supporting. This witness has also considered that she gave a common option to both these accused persons. She has also stated not to have obtained the willingness of the aforesaid accused persons to be searched before her separately.
My lord.
Strangely, PW 1 and 7 associated by the PW 8 during the alleged search have turned hostile.
The official witnesses also turned hostile.
That is the
and
problem.
Including the
That is the problem.
witnesses. But
Then
my
how
submission is no, my lord.
there is a you see it is a case where you say that prosecution has a 30% case. So 30% case should be 100%. That is the difficult question for the court.
That
You
is
may
there,
say
but-
that yes, that he has supported PW8 has supported PW8 has proved certain things. But again 42 regarding compliance with 42 and other mandatory provision.
No, in only there are, my lord, two things I find. One is he has not complied in section 50.
Yes.
He has not written it down or he has not intimated to the authorities, and also PW deposition of the PW8.
Others have not
also
supported.
Yes.
Actually, if others would have supported that,
Yes.
then the court would have. But still, I think for not complying with 42 1 and 2 is fatal.
Yes.
That is my understanding.
Now 50 mu ଟିକେ ତାପରେ decision ଦେଖିବେ।
42
କାହିଁକି
1 2 ରେ ଦେଖ
compliance immediately suppose
42 1 2 finding ଦେଇଛନ୍ତି page 10 ଦେଖୁନାହାନ୍ତି
ମାନେ
page 10 rather page 9 sentence ଟା page 9 ରେ ଆରମ୍ଭ ହେଇଛି ଗୋଟେ ଲାଇନ ଅଛି
page 9 yes
page 9 last ଦେଖନ୍ତୁ
yes
thus there is apparent non-compliance of the mandatory provision of law enshrined in section 42 1 and 2 of act.
yes that is it comes
See जो discussion କରୁଛନ୍ତି PW8 କଣ କହିଲେ
Well.
obviously they say he has not gone to other witness, but I think if they would have complied with 42 1 and 2 the mandate statutory mandate would have
yes
been
yes my lord, that
fulfilled.
is there only my endeavor would be my lord to go
देखो ଆପଣ examine କରନ୍ତୁ
decisions yes
କେବେ ଆଣିବା କୋନ
my lord
କେବେ when it will be listed
first week of December lord
first week December date କରନ୍ତୁ Mr. S.S. Mahapatra AC after advancing some arguments for seeking leave to appeal seeks further accommodation to examine the statement of the PWs by going through the depositions as spread for list on 11th of December 2020.
my lord.
Yes.
Item 9.
My pleasure, Lord.
Yes.
Offense malfunction 376 2N and
Mr. Ajit Kumar Raut for the Mr. Raut
My lord.
for the petitioner.
Your lordship, my lord.
The statement जो deposition रे किछि anything favoring the
My
accused अछि
My lord.
164 statement आपण ଦେଇଛନ୍ତି deposition copy ଟା तांको
yes
ଦେଇଛନ୍ତି
yes my lord, I have
We
gone
do 7,
through.
my lord.
PW7 नाही प्रोसेस आपणकर हमर victim रो state किए केते number
We do 7.
7 okay
Lord.
7
Yeah, Lord, the petitioner was
ଟିକେ ରୁହନ୍ତୁ ମୁଁ ପଢେ
last page.
the accused has said that he'll be marrying
My lord.
So Dwivedi,
My lord, on behalf of SK Dwivedi, kindly taken up next week, my lord.
where is Mr. Hota today? Because Hota represents Mr. Dwivedi. Your name, sir?
PK Barik.
You don't have power. Mr. PK Barik on behalf of Suryakanta Dwivedi, S. Dwivedi for the petitioner. Mr. S.S. Mahapatra, additional standing counsel for the state. The learned counsel for the petitioner seeks accommodation. Seeks further accommodation. To advance arguments. The direction thila dawa pai affidavit gote FIR copy apana deithile anyway chadon apana to brief nai kon lekhile kati lekho to the adjournment is sought for on behalf of the learned counsel for the petitioner as prayed for list on 7th December 2023 to grant further opportunity to the petitioner. The learned AAC submits here case diary is available.
Yes, ma'am.
Submits that case diary is available. Yes, next. Sub item re kohuntu sir पढ़ांतु नी आउ दीटा मैटर हिच अपन लिस्ट देखु नांती की मेंशन भी करिवे ओटे देखिबे ना एजे कोन डिफेक्ट अछि सेम ऑर्डर कर देबे सब आइटम रे यस
Item 11, item 11 after lunch. After lunch.
Passover to be called again
Public.
at 2 p.m. Yes.
12,
Same as एटा कोन गोटे अफेयर ना अलगा
No, no, my lord.
जानना आंती
11. Ten, my lord.
12.
12, man.
I think 12 is a separate matter, but here no anyone appearing for the adjournment is appearance rahila Mr. Barik,
PK Barik.
Mr. for the S. Dwivedi for the petition, Mr. S.S. Mahapatra ASC. Adjournment is sought for on behalf of the learned counsel for the petitioner to grant further opportunity. List on 12th of December 2023. The registry shall do well to again intimate the learned court in session of the matter as well as the secretary DLSA Balaso to intimate the victim oblique informant oblique victim regarding the next date of hearing and also provide legal aid as far as their right of audience in the present proceeding is concerned to be represented through a legal aid counsel as noted earlier in order dated 10/10/2023 as indicated earlier in the earlier order dated 10/10/2023. Yes, next.
13,
My lord, on behalf of Mr. Mahanti, I'm seeking an adjournment.
Your name?
Ananya Mishra.
M.S. Ananya Mishra on behalf of Suraj Mahanti for the petitioner, Mr. S.S. Mahapatra.
Case is available, my lord. Only petitioner number 2 criminal antecedent has not been received. If he is adjourning, my lord, I'll be getting that. 1 has been received, but 2 has not.
It is called like that. You are on behalf of Mr. Patel.
Mr. Suraj Mahanti, my lord.
I am for the informant.
It has been transferred to Mr. Mahanti. Aguru Thile Mahanti, Tapare Batan, Vijay Ragada and Ellen Patel. Now Mr. Ragada is not appearing. Mr. Patel,
My lord,
Mr.
Mr.
Dora.
Ragada is actually, he has joined as government counsel in the.
I understand, sir, madam. I understand, but I don't know. Anyway, dekho ki kitna wakalat na. Quiz jari. The learned adjournment is sought for on behalf of the learned counsel for the petitioner. Vijay kebe file karchoti? Date? 7/5. You verify after engaging. He has again engaged Mr. Patel and Mr. Ragada and associates because your okalatnama is 21st April and Mr. Patel's wakalatnama is 7th of May.
My lord.
As prayed for list on 7th of December.
My lord, I'll further date if possible.
Karantu date further. 7/12 ଆଗକୁ କରିଦିଅନ୍ତୁ. 18th December, the learned AC submits that the antecedents regarding criminal, the petition number 1 is available.
Yes, my lord, 2 I'll bring it.
And he shall obtain the antecedents, comma, if any, of the OP number, the petition number 2.
Ma'am.
Case diary is otherwise available.
Yes, yes, ma'am. Case
He
diary,
submitted case diary is otherwise available.
Yes.
Okay.
Yes.
14.
To be called again. 14 ଆପଣ ଅଛନ୍ତି?
I'm for the info analysis.
Mr. Behra,
14 my lord, one password prefer.
to be called again.
One password.
ଦେଖନ୍ତୁ ତାହେଲେ ଆସନ୍ତୁ।
Only one password. No?
ନାଇଁ ସେଟା ଦିଟା ବେଳେ ଅସୁବିଧା ହବ ନହେଲେ କାରଣ
Yes,
ଭ୍ୟାକେନ୍ସି ବ୍ରେକ୍ କରିବାକୁ ପଡିବ ଫେରେ। ଆଜ୍ଞା
Alternative, one password.
ଅଛି।
Just.
ହଉ ଠିକ ଅଛି।
Problem.
ଅଥର ଡାକ।
15.
Miss
Paper
Tilata
one
Bala on
week
behalf of Manoranjan Padhi for the petitioner, Mr. S.S. Mahapatra, AAC for the state. Yes, what do you want, madam?
paper 1 week after.
The learned counsel for adjournment is sought for on behalf of the learned counsel for the petitioner. As prayed for list on 8th of December 2023.
Case diary
The
available.
learned AAC submits that case diary is available. Eyewitness account is there.
Yes, yes, ma'am.
Yes.
16.
I am S.K. Bose on behalf of Mr. B. Singh, my lord. Who is
S.K. Bose, Mr. S.K. Bose on behalf of B.B. Singh for the petitioner. What do you want, sir?
my lord, 15 days time.
The
2 weeks time.
learned counsel for the adjournment is sought for on behalf of the counsel for the petitioner. As prayed for list on 13th December to grant further opportunity.
Case diary is available.
The learned AC submits that case diary is available. Yes.
17.
17. Miss Bola on the same order.
Next week.
Same order. 17 same as 15.
Item
Date के 17 में कर ले 8 है 8. Yes, Mr. Tripathi.
item 14.
Yes.
I prefer is short adjournment.
So Amitabh Tripathi for the petitioner. Mr. 14, Mr. Mahapatra, you are 14. He made one passo.
14 case diary is not available. I will bring it.
Mr. S.S. Mahapatra, AC for the state. Learned counsel for the petitioner seeks accommodation to advance arguments. As prayed for list on. Mr. Swine, you are Mr. Arun Kumar Das.
Yes, Lord.
Mr. Appearance likhi Mr. Arun Kumar Das for informant. The learned AC shall obtain up-to-date case diary
Up to case diary.
and statement of the 160 statements recorded under 164
Yes, yes.
CRPC, comma, if any, as well as other relevant instructions. Yes, next.
Surrender. Sir, they have.
18.
My lord, 1 week time may be given to file an affidavit, my lord.
Your name, sir?
Pratap Kumar Behra, PK
Mr.
Behra.
P.K. Behra on behalf of M.K. Mahapatra for the petitioner, Mr. Devasis Naik.
My power is there, my lord.
এটা କେତେ number? 18.
18.
ସେଟା ଆପଣ ଏଟାକୁ ଆପଣ opposite party କରିଦେଇଛୁ. So P.K. Behra for the petitioner, Mr. Devasis Naik, AGA for the state, learned counsel for the petitioner seeks accommodation to comply with the earlier order. Dated 9/10/2023 for a filing affidavit on behalf of the petitioner indicating any past allegations.
CD my lords is yet to be received.
The learned AGA आज prayed for आगे लिखो तो आज prayed for list on 13/12/2023. The learned AGA shall obtain the up-to-date case diary,
My lord.
oblique instructions. तापर उटे line लिखंतु. The name of the associates of Mr. M.K. Mahapatra for the petitioner has been wrongly typed in the cause list appearing for the opposite party. Cause list be corrected.
19.
May I please, Your Lordship?
Yes.
My Lordship, I am on behalf of S.A. Hafiz.
Your name, sir?
My name is Santosh Kumar Ojha.
No power. Mr. S.K. Ojha for the petitioner. Mr.
Kindly-
Devasis Naik AGA for the state.
Kindly
And
adjourn this
counsel
matter.
for the petitioner seeks accommodation due to non-availability of the arguing counsel as prayed for.
Kindly adjourn this matter for 2 weeks after.
14th December.
Yes.
As prayed for list on 14th December to grant further opportunity. Here case diary available, Mr.
My
Naik?
lords.
The learned AGA summons that case diary is available. Yes, next.
20.
Mr. S.K. Patnaik for the petitioner, Mr. Devasis Naik AGA for the state. Yes, Mr. Patnaik. The learned counsel for the petitioner seeks further accommodation as prayed for. List on 14th December 2023
Case is available.
to grant further opportunity. The learned AGA submits that case diary is available. Yes.
21.
My Lord, 21, kindly adjourn this matter for 2 weeks.
Your name, madam?
Jayanti Das on behalf of Surekan Das.
You don't have power.
So no.
ଆପଣଙ୍କର ଏଥିରେ ଓକାଲତ ନାମରେ ପାୱାର ନାହିଁ ବୋଧେ ଜୟନ୍ତୀ ms.j das DASH
DAS.
DAS for SK Das Mahapatra,
Yes, my Lord.
Mr. Devasis Naik AGA for the state. Accommodation is sought for on behalf of the learned counsel for the petitioner to grant further opportunity. List on 11th December 2023.
To call for the CD.
Bless you.
The AGA shall obtain up-to-date case diary and instructions.
There's a sub item, my lords, also in this matter.
Sub items, ଆପଣଙ୍କର sub item ଗୋଟେ same prayer,
Yes.
same order appearance and same. Yes, Mr.
22.
May I please, Your Lordship?
Yes.
No, the charge sheet has been filed against the petitioner.
Status of trial ପାଇଁ order ଥିଲା.
My lords, neither status of trial, my lords, CD, both not available.
Mr. S.K. Pradhan for the petitioner, Mr. Devasis Naik AGA for the state, learned counsel for the state shall obtain up-to-date case diary, status of trial. List on 12th December.
My lords.
Yes, next.
23.
Mr. S.C. Mahapatra, senior counsel, instructed by Mr. S. Mahapatra for the petitioner.
May I please, Your Lordship?
Yes.
This is a case where the petitioner was charged sheeted for commission of offense on section 302,
Yes.
498A of the Indian Penal Code. My lord. He was taken to custody on 1/4/21. And
Here, after your submissions, after 39, 9 have been examined.
7 witnesses deposition copy has
7
been given.
witnesses has been examined.
9, this is 3110, the learned ADJ Kotak in charge, third additional. He says he has been transferred.
Yes. Now, no presiding officer has been joined till yet.
What is the overt act alleged against this petitioner?
No, there is no direct evidence. The case is based on circumstantial evidence.
Yes.
The deceased is the wife of the present petitioner. It is said that on 28-29 March 21, the deceased was found
He's in custody since?
custodied at 1/4/21.
Mr. Naik,
My lords.
the learned presiding of, the learned ADJ writes, further resumption of the trial and the eventual completion would be apprised after joining of the new presiding officer. No, I'm just sharing because you are not aware what is there
My lord.
with the administrative side.
I am suggesting one thing for both the sides. It will be better to release him on interim bail for certain period. Thereafter, if the PO will join in between, the case will continue. Because we are not sure when the PO will
No,
join.
he has in fact written that.
Okay?
He has actually, after I wrote this, or the order was passed to apprise the court regarding the present status of trial. The registry shall request the learned court in session of the matter to provide the details of likelihood of the time to be taken for completion of the trial and the present status of trial. So he's already in custody since 1 year, almost in January he'll be completing 2 years.
My lord.
A total of 39 witnesses, out of which 7 witnesses has been examined.
He has written 9, so it makes there is not much variance also. He is also saying 7.
The circumstantial witnesses were the most important ones have not been examined. Only the IOs and
I understand, but the now he says that I can tell something after the presiding officer joined. So I'm in a fix actually.
difficulty. My lords, if this was any other
Order dated 6/10/2023, the following was directed. Paragraph 3 ta quote kar debe. In response to the said direction, the learned third additional session judge Cuttack has furnished a report which states thus. Bariku eta dekha jauni tige. With regard to the last paragraph, a report dated 31/10/2023 addressed to the registry of the High Court, registry of this court, which indicates the following. With regard to the report sought for to Neki, new presiding officer to this court. कोट कर देबे जे देखा जीवनी सेटा फिजिकल कॉपी रे देखि देबे एटा देखा जे स्कैन हला पर एटा दुसुनी the learned senior counsel seeks sought accommodation. How much time, sir? केबे आनले हबो
गोटे वीक छाडी कि आसिलो
ए आजि केते हला आजि 17 नहीं आज 17 न आजि 20 on 28th
and
list on 28th you filed that petition and survey copy. Yes, Mr. Naik.
No, my lords, up to date status. My learned senior was saying. I said there's no
status is there. You can show him. You can see
there is no presiding officer, so no question of it.
He says that I will intimate the up to date status after the presiding officer joins. So I was thinking how to go about that. And in Cuttack, as such, there is workload is very high.
It's clear. Section 27 discovery also. I mean,
that could be, but this is not
I know, it's a very
with person to incarcerate because the matter is not taken up. That's a significant consideration. Either it is to be expedited, concluded, fair enough, he is convicted, or acquitted. I don't. There is no presumption of conviction, of course. Rather, there is a presumption of innocence.
Oh, because getting bail on these grounds, my conscience does not work.
Yes. Obviously, you will not say. In fact, I could not handle that actually. So I simply quoted and adjourned it.
Let's the next item, my lord, is supposed to get some instructions. My lord, may kindly give me about 1 week's time. I'll get
this is item. Which item?
This is 24.
24.
Who to instruction?
Yes, this is the Gujarat case, my lords.
That Gujarat case,
my lords.
That information is yet to be received.
I'll follow it up, my lords. Personally, I'll need some time, 7 to 10 days.
Mr. Basudev Pujari for the petitioner, Mr. Devasis Naik AGA for the state, Mr. Jitendra Samantray, J. Samantray for the informant. The learned AGA referring to the earlier order dated 6/10/2023 submits that instructions from the police / law enforcement agency is yet to be received in terms of the said order. As prayed for, how much time, Mr. Naik?
About 2 weeks, my lords.
As prayed for 2 weeks.
In all local cases, he is on bail.
No, my lord.
I think he has jumped bail, Mr. Pujari.
He has jumped bail, and
but problem is that I am unable to direct them to produce any records.
Nobody can. That is the problem.
That is the problem.
So that's
2 weeks ele 12 hoji. 12 December.
Gote saptah deytantu.
Tale first week December rakhantu. No, the next week is actually December. Friday, Saturday, December. 6th of December. Yes.
25.
रे कौन न्यू एडवोकेट आपण नुआ ना आपण पुराना सर
Nua.
कंप्रोमाइज एफिडेविट कौन ब्रदर देले कौन
Copy of that affidavit may kindly be.
पैसा दे देली कॉपी देथिला ମୁଁ
Compromise affidavit copy.
କିନ୍ତୁ ମୁଁ affidavit
आपण इन्फॉर्मेंट की अपेयर करछंती
informant
जदि आपण you are addressing that the informant has done some I mean you have entered into any kind of so informant should be present with informant को पार्टी करछंती
नहीं informant पार्टी
तांको आपण माने S. Harichandan, who was appearing earlier, shall be deleted from the cause list as well as the case brief, retaining name of Mr. A.R. Maji and associates who have entered appearance after the consent of the learned counsel who was engaged earlier. The learned counsel for the petitioner shall file affidavit filed on behalf of the petitioner by one Sri Uttam Mahanti, stated to be the brother of the petitioner, and Mr. and on date affidavit file kale 6/11/2023 आ गोटे होची affidavits dated 6/11/2023 and 3/10/2023. Comma indicating allegations, past allegations against the petitioner, comma if any. Stop. Kebe affidavit kebe serve koribe? Affidavit be served today.
today
Affidavit be served by 2 working days. The state shall obtain instructions in the matter. Learned counsel for the state shall obtain instruction in the matter. List on 4/12/2023. Mr. Maji, just in the last matter where you are saying you have filed affidavit, they have entered into a compromise or whatever. But before the Learned Sessions Court, you have taken a stand that I have returned the money. Then why you are not doing that here?
after the instruction
Obviously, list on 13/12/2023 as prayed for. 13th of December. The registry in the cause list, it has been indicated compromise affidavit court lekhibe. Court compromise affidavit on court, which apparently is a typographical error. No such affidavit is available. The correct word would be comprehensive affidavit. Cause list be corrected accordingly. Yes.
Case under section 341, 294, 326, 307, 556.
What is the highest punishment? And the matter may be adjourned to obtain up-to-date instructions. As prayed for first week of December.
Yes.
List on
14 बार
first week को दे दियो 4 ने के 12 में होची
7
7/12. Yes.
28
I pray for 2 weeks after.
You are Mr. Das. Mr.
My
Devabrata Das for the petitioner. Mr. Devasis Naik AGA for the state. The learned counsel for the petitioner seeks accommodation to advance arguments. You have received case diary and section 1.
Case diary is there, but 164 statement and DNA test report is yet to be obtained.
The learned counsel for the petitioner seeks accommodation. As prayed for list on 15th of December. 15 December 2023. To grant further opportunity. The learned AGA shall obtain up-to-date case diary. The learned AGA submits that he has received up-to-date case diary, but the copy of the statement of the victim under section 164 CRPC and some further instructions are awaited. The same shall be obtained by the next state.
29
I pray for 18th, my lord. Instead
18th of December.
December.
कर दियो ना?
My pleaders.
Yes, 20.
Last occasion, Your Lordship.
You are Mr. Naik,
My lord.
Mr. Ramakrishna Naik, R.K. Naik for the petitioner.
My lords, I have to obtain the CD, my lords, in this case. I haven't yet.
Affidavit copy you have received.
My lord, already given.
There is an affidavit at flag K that is dated 9th November.
Nahi. My lords, I don't have that affidavit.
I would a copy de diyantu. It might have been misplaced.
I have the 164.
Achi. Yeah.
Bullets. 29. 29.
College re podu.
My lord, I'm sorry.
Even some wrong things.
There is 29. My lords, my mistake, my lords. This is item 29. By mistake, I have given the wrong.
This is which item?
That is, my lords.
This is 29.
31. This is 31.
No, 29 brief you are holding, still holding.
29 I'm holding. 29 criminal antecedents I have not received. That is what I was submitting. I'm so sorry.
Okay.
One criminal antecedent has been, my lord, reflected in
Yes, you have given that 29 affidavit you have received.
I have affidavit I have received, but the instructions on affidavit I have not received.
The Lord Counsel for the state seeks further accommodation to obtain response to the affidavit filed on behalf of the petitioner indicating the past allegations of criminal activity. How much time, Mr. Naik?
Minutes a week.
I spread for 8 bar दियो so गोटे कहउछन ना today is 17 आज केते date 20th Eastern 3011
my lord, one thing, pray, my lord, 4 years in custody, my lord, the present petitioner, near about to 4 years. My lord, sudden provocation.
से आपरे गले आ बाहरी परिबेनी बुझ पर नांदी आपण जहा करूचोंदी से ता गोटे पर गोटे करी 4 वर्ष रहलेनी से बर्तन सेठी रहिले पूरा से आसंतु आपण व्यस्त हेले केमति हो यू हैव टू बी मोर पेशेंट देन योर क्लाइंट
my lord, sudden provocation.
से प्रोवोक हे जानती कोन करा जीव आपण कोर्ट कैन नॉट इंपोज दैट ही विल नॉट बी प्रोवोक्ड दैट्स द प्रॉब्लम henceforth he shall not be provoked. How can the court will ensure that?
Item 30.
Item 30, I pray, kindly take note to chapter 1.
And I am appearing for the information.
Okay. So that registry file kar debe. Mr. S. Harichandan for the petitioner, Mr. Devasis Naik AGA for the state. 30 you are given the
what I
case,
just
please.
handed over, my lord, at 164.
Yes, what do you say? About adjournment kain korchon? ନିମନ୍ତ୍ରଣ କରିବେ କି ତାଙ୍କୁ ତାଙ୍କୁ ଏଠି କଣ ନିମନ୍ତ୍ରଣ ହେଇପାରିବ ହେଇପାରିବ ମୁଁ ତ ପଢିଛି ତାକୁ ସେ କଣ କହୁଛନ୍ତି ଆପଣ କୁହନ୍ତୁ
I am appearing for the information, my lord.
What is your ମାନେ instruction?
Is it about 6 years, my lord? The life risk is there if you will release on bail, my lord.
नहीं इसी तरह से 8 नो 6 नो एटा
30, my lord, BLPL 8509. Huh?
15 she studies in which college? Because it's not the now it is
And at BLPL 8509, your lordship kindly glance hold.
8509 ଆପଣ 6 years କହୁଛନ୍ତି ନାଇଁ ନାଇଁ ସେ କୋ କଲେଜ ରେ ପଢୁଛନ୍ତି because the minimum age now admission age has become 6 in this generation the admission age is 6 years first standard 1 or class 1 ADJ, Lord ad hoc additional, Lord ad hoc ADJ into bracket fast track sessions court. Has not provided any further instructions. Any instructions? In terms of the earlier order dated 28/8/2023. The registry shall do well to inform the learned court in session of the matter. To ଆପଣ extra copy ଦେଇଥିଲେ registry କେବେ ଦେଲେ?
Earlier, as per direction of this court, supply.
Through its office, the learned court session of the matter through its office shall inform the informant oblique victim regarding the right of audience in the present proceeding. The learned secretary DLSA shall also do the needful for engagement of counsel through legal aid if the informant oblique victim are unable to engage any counsel on their own. The next date of listing shall also be intimated by the concerned IAC.
That I am appearing in.
I'm sorry. Upon legal aid na normal report?
Normal.
Kon likhle? Since the learned counsel has already appeared on behalf of the informant oblique victim, no further instruction is necessary from the learned court in session of the matter. Kibe chahunchandi Mr. Harichandan?
Yeah, 2 weeks after now.
Date karantu. List on 13/12/2023 to grant further opportunity to the petitioner. Learned AGA shall obtain up-to-date case diary statement of victim recorded under section 164 CRPC and other instructions. Yes.
31. Matter has been infructuous, my lord. That's because, my lord, the petitioner has got acquitted before the court below and at trial has been completed.
সেটা দিয়ুন তো, details দিয়ুন। Mr. A. Patnaik for petitioner, Mr. Devasis Naik AGA for the state. Learned counsel for the petitioner submits that in the meanwhile the trial has been concluded and the petitioner has been acquitted of the charges. Details shall be kebe debe details.
My lord, I'll
Kebe
15
din lagyo aniya pai ei jinsa
ଗୋଟେ certify copy
certified copy mu kon sir mu
ମୋର
detail not
not
date of order the registry
not
shall-
trace କରିଦଉଛି not
the
trace.
registry shall obtain the details of the such order from the learned court in season of the matter.
My lord, I prefer not trace.
Additional district session just come POCSO by the next date. आज कितने तारीख है? 20 List on 30/11/2023. Yes.
32. May I please, your lordship, my lord? Here
Yes.
the petitioner custody 8/1/2023.
Shamuliratna Ponda for the petitioner, Mr. Devasis Naik AGA for the state. Yes.
And my lord,
Mr. Padhi, you are there.
My lord, I am the for informant.
Informant. 33. Will be called again. Yes. At 2 p.m. Yes, next.
34.
Will be called again.
35.
If I may please, your lordship.
Yes.
In this case, offense under section 394 of IPC and 2527 Arms Act. Petitioner is in custody since 14/6/2023, and here charge sheet has been filed against the petitioner and another, keeping the investigation open for another person. There it is alleged that there are 3 persons who snatched a bag containing cash of ₹5 lakh from that informant, and they're unknown. FIR is against unknown persons. And
Here the age of the petitioner is?
Age of the petitioner is 24 years. And as
you have served copy of the affidavit on the.
Yes.
Yes.
It is in sync with your instruction also.
Yes.
Mr. Mahesh Das for the petitioner, Mr. Standing Counsel for the state. The learned counsel for the petitioner submits that the petitioner is in custody since
14/6/2023.
The final prosecution report has been submitted on.
Charge sheet final report has been submitted on 11/8/2023. Not final.
2023.
Not final. It is preliminary.
Keep preliminary prosecution report. FPR tag preliminary kar diyo. Preliminary prosecution report has been submitted, keeping the investigation open regarding a co-accused.
Co-accused.
Keeping the investigation open for a co-accused. And it is submitted considering the period of incarceration and the fact that and the age of the petitioner being 24 years.
Right.
He should be given a chance to come back to the social life. He may be shown indulgence as far as the prayer for bail is concerned. It is submitted that petitioner being a local resident shall subject himself to the jurisdiction of the learned court in session and shall also abide by any stringent terms and conditions, any terms and conditions that would be imposed for grant of bail. The learned standing counsel, referring to the materials contained in the case diary furnished by the investigating agency, opposes the prayer for bail. However, it is not disputed that the preliminary prosecution report has already been filed as stated, keeping the investigation open regarding the other co-accused. Having heard the learned counsel for the petitioner, the learned standing counsel for the state, and considering the material on record, This court is inclined to grant bail to the petitioner subject to such stringent terms and conditions that would be imposed by the learned court in season of the matter, which shall also contain the following conditions: that a member of the family of the petitioner shall stand surety, then semicolon, para, any violation of oblique deviation from any of the terms and conditions that would be imposed by the learned court for grant of bail shall result in filing of petition for cancellation of bail by the law enforcement agency, disposed of accordingly. Yes, next.
36.
36, yes, 36, 36.
My lord, may I correctly take note next week, my lord, on behalf of Mr. Pramod Kumar Jena.
Your name, sir?
Priyaranjan Misra.
Mr. P. Misra, P.R. Misra, P.R. Misra on behalf of P.K. Jena. For the petitioner, Mr. Standing Counsel for the State, the learned counsel for the petitioner seeks accommodation. Sorry, prayer for accommodation. Prayer for accommodation is made on behalf of the learned counsel for the petitioner. As prayed for list on 15 December. 15/12/2023 to grant further opportunity received. The learned standing counsel submits that case diary has been received. The rest of the matters after recess. Any mention?
No. Pardon to make a mention, Lordship. Item 43 and 44. It's a transfer bill, Lordship.
So wait.
Today we have filed the VNAMA, Lordship.
Whatever you wait and then let that order has to be passed. I have to dictate that order. And this is the orders matter. Why I will then ignore others? The starting with 32. If you have any difficulty, then just inform any of your friends. You can inform any of your friends to mention on your behalf. Ranjan Mahapatra on behalf of Somnath Satpathy, S. Satpathy for the petitioner. Mr. Standing Counsel. Yes. Item 11, you are there or Mr. Naik?
Mr. Mahapatra was there, my lord.
Mr. S.S. Mahapatra, AC for the state. Yes, there is an order to obtain instruction, Mr. Brundavan Raut for the informant. Yes.
Well, here the allegation against the present petitioner.
What was the last order to obtain instruction?
Obtain instruction, the state council was directed to obtain instruction.
My lord, he has filed the affidavit saying criminal incident, my lord, regarding 340 Hon'Ble PS case 345 2022.
Yes.
346 22 and 349. As per our record, it is 347, not 349. He has stated, my lord, 349. In column number 3.
But number and nature of allegation and total number of allegations are same. Okay. What is the maximum punishment prescribed in the present case?
420, my lord.
420. के जनठू नेइतिले आपण टंका
जणे
जणे कोन तीनटा एफआईआर देले
नहीं नहीं यही जो तीनटा एफआईआर हेची सेटा आउ जनकर जो सेठी पीएस केस नंबर 345 PS case number 345 that is relating to that my amount was paid for to get the loan sanction because the petitioner was working as the agent of the cooperative bank. So
do you have any instruction that you'll deposit some amount in the court below?
The condition of the petitioner is not. That's why he is in custody for last
after defrauding so many people with so much of money, they have become poorer.
Taken money.
For last present case, 10 months he is in custody. For last
present case, my lord, he has taken 21 lakhs. Since you have taken
21 lakhs. 21 lakhs.
So where is all that money gone? You obtained instruction because that's a trend set by earlier orders.
This was also in my mind regarding payment of some amount. I instructed that relative of the client to be prepared for deposit of some amount. And I got the instruction that he is not financial condition is not like.
How he will survive coming out? He will have no food, no place to stay. Now at least he's a state guest and getting food, and so he's in such a precarious condition. And after cheating so many people, targeting, basically this is a targeted cheating. The problem is he's targeting people to extract money.
This particular case is a breach of contract because there was a contract agreement was executed between the informant and the present petitioner that he will hand over a piece of land, and all these things were there.
So let him have second thoughts. We just adjourn it.
On the 6/10 it was adjourned. On the said date, my lord, petitioner took time for my lord getting instruction about the deposit.
No, that's why I'm submitting, my lord. I got the instruction, my lord. His financial condition is not like to deposit.
How much total money upon dechandi?
In this case, 21 lakh. In this case, 21 lakh. And in PS case number 345.
This affidavit is not in terms of 6/10 order. This is not in order.
In tabular form.
Chart regarding earlier allegation against the petitioner, the status of each of the cases, also indicating the amount involved in each of the cases.
Yes, I have given that.
No.
You have given only paragraphs.
No. That affidavit not. I'm not. 7/11/2000.
7/11, you have given another affidavit.
Yes. 7/11 in tabular form that has been given. The amount has been indicated in respect of each cases. The first case is 345. That amount involved is 5 lakh. That is a PS case. And another is 2 lakhs. That is PS case 346.
So after at least alleged amount is 30 lakhs. So he has gone poorer. So let him stay for some time and enjoy the hospitality extended by the state. You see, unless the problem is that
looking into all these things, your lordship may pass the appropriate order. Looking into the interest of the informant as well as the.
No, I'm not, because that amount cannot be withdrawn by the informant.
Yes.
Second part, this is not a precondition for grant of bail. This is a behavior shown by the person to seek indulgence of the court. Because there is also a view of the order of the direction of the Supreme Court that perhaps court cannot ask for, in this proceeding. In this proceeding also, there can't be any restitution of whatever amount you have received. But you can show that behavior. You ask to him.
My lord, my direct.
No, because that will frustrate. How I will not direct. Must understand.
On the last occasion, lordship direct to file an affidavit. On the affidavit, all the cases is on the bail.
So there is also a condition that whenever released on bail, he shall indulge in similar criminal activity. So that's a point in against the petitioner, that repeated indulgence shown by different courts is violating that.
2011, there are 2,000 people, sir.
My lord, kindly see the affidavit and the criminal.
No, affidavit is not on record. You have saw. Are you aware what he's saying? He said it is at variance.
Yes. Rejection order, there is.
So it has to be rejected.
Yes, my lord.
If you do not file a correct affidavit, it will be rejected.
No. Is in affidavit, my lord, he has given about 3 cases.
Starting in the year 2011.
3 cases.
Whenever you are released on bail, then you indulge in criminal activity.
No, my lord. In the 2011.
Then what affidavit you are filing?
There is a wrong. There is a tussle between the village peoples and that person.
Sir, what is no you are saying? You have been acquitted.
The trial is not been commencing.
Then every time you are granted bail, you are looking for an opportunity to commit the crime again.
Including one
under 2011, which they have in another case. In that case, he is on the Surat jail millers.
The allegation your lordship may see what type of offense, my lord, they have committed. My lord, probably, my lord, in order to, my lord, give threat to a witness, they have committed
an accused.
My lord?
You are a law unto yourself.
2011,
you are all accused in allegation called 395. Then in 2011, there is another 506, 395.
Your lordship on that occasion.
My lord, kindly see the.
You are filing affidavit today, or say copy. He is giving today, copy today.
Yes.
So you have to obtain instruction.
But I got the instruction just now. Actually, I got the instruction.
And 1011, Lordship, the direction that the appeal has been filed in these two cases. 2011 cases.
So filing of appeal that you are innocent.
The 2011 ମୁଁ ସୁରାଟ ଜେଲ ଥିଲି ତାର
Apart
ରିପୋର୍ଟ
from
ଆସିଛି
this present case, my lord, there are other 5 cases. Only affidavit has been given in respect of only 2 cases, my lord.
Yes,
First-
2015 2016
The
ଦିଟା case ଆମ
affidavit
appeal
in
file
respect of
ହେଇଛି
first case, my lord, that is the present case.
9434 9441
Se jani nahanti. You have a case starting with Kodola PS 2011, then another the same Kodola PS case. Then in 2023, another case. I think he's getting on that Kodola PS case. There are 3 cases. How many cases you have indicated?
there are 3 cases my lords.
No. In Kodala, most probably there is, my lord, 4 5 cases. All the cases belongs to Kodala.
115, 116 and 117.
All those were belongs to Kodala. Man.
Under 2011 but he is in the Surat jail my lords.
Sir,
These are
remaining in
recommendations to
remaining in jail he committed, that's not a consideration in 439. You produce that certificate and get acquitted. Then why you have filed appeal against that case? So how you have been convicted?
No, SC/ST ଲାଗିଥିଲା sir.
Yes.
SC/ST case trial ବି ହେଇନି 2000 ଲୋକଙ୍କ ଭିତରେ ଗଣ୍ଡଗୋଳ ହେଇଥିଲା
Sir, 2 ଜଣଙ୍କ ଭିତରେ ଗଣ୍ଡଗୋଳ ହେଲା କି 100 ଜଣଙ୍କ ଭିତରେ ଗଣ୍ଡଗୋଳ, that's not the issue. The issue is you have filed appeal against which case? Because you have got acquitted. Why you have filed appeal? Pending in this court.
Last occasion Lordship directed Mr. Pujari when the SC/ST is in there, the report is come and filed an appeal, not bail petition.
I could not follow you, sir. Appeal filed against bail petition.
Yeah, in bail,
Sir, 94
in SC/ST matters, my lord, bail application filed in appeal.
Appeal, okay. That provision is for appeal. Okay.
Your lordship may see the allegations, my lord. This person doesn't, although 3707 Arms Act right there, my lord. Your lordship may kindly see the rejection order.
Injury seizure sir କିଛି ହେଇନି जो ଭରଣା ଗାଡି କୌଣସି ଗାଡି ବି ସିଜ୍ ହେଇନି
Because, my lord,
ଯେହେତୁ ଆଗରୁ ତାଙ୍କର ଏନିମିଟି ଅଛି ଗାଁ ଗାଁ ଭିତରେ ତା ଭିତରେ ବିଜନେସ ଶତ୍ରୁତା ସେଥିପାଇଁ ଗୋଟେ ମିଛ ଗୋଟେ
from rejection order, your lordship will get the clear picture about the involvement, my lord.
ସବୁଟା ବେଲ୍ ଅଛନ୍ତି
Para 3, your lordship may kindly see.
ରିଜଲ୍ଟ ସବୁ ତାଙ୍କ ବେଲ୍ ଅଛି
You see what kind of activity you are indulging after being released on bail. Now the bail cannot be granted. At this stage, it cannot be granted.
So, example, Mr. Pujari, the Friday,
Mr. B.K. Naik for the petitioner, Mr. Standing Counsel for the state, and counsel for the petitioner after arguing for some time, once adjournment, as spread for list on 28/11/2023. Specifically 28 likhi rakhle na? Yes. Next.
34.
Yes, your matter will be taken up after this passed over matters. You have any other matter anywhere?
Yes, not exactly, sir. One matter I had to do it here, virtual millard.
Yes.
Because there are so many matters not fixed today. That is the reason.
Okay.
I did just now a matter virtual millard in my lord's corridor.
Yes.
But this was though direct.
Scan in a copy. Physical copy.
In fact, I have not also brought the record on this case. She made a mention and mention was made without informing us also.
So you were for the other side.
Yes, but this was the mention was made in the first hour. If we had been informed little before.
I'm sorry. No, that I didn't realize.
But if
I thought that you mentioned the matter.
No, Milad.
I'm sorry. Yes.
My lords, the matter was directed to be listed today on the 16th, my lords. When I
No,
informed my lords about
that
the
is how I have
listing-
been telling all of you that whenever you get a matter very short adjournment, there is a difficulty in returning the file.
Please,
It
my
can't be
lord.
listed, and it was, I think it was listed on
Thursday, my
17th.
lords. It was listed on Thursday, my lords. Thursday last
Thursday
week.
after that.
Anyway, my lord, in fact, since the matter is not in the board, if you make
No problem. I'm not taking up. I'm not taking up.
That's right. My lord, in fact, I would not say that.
Let it come on 22nd.
But 22nd.
22nd or any other subsequent day.
My lord, 22nd, I have a personal problem. I've been invited as a speaker to speak on with regard to legal subject, my lord. It's a national seminar.
When do you want?
My lord, any day after 22nd, I have no
My
issues.
request for the 24th, if it is possible.
24th? Okay.
My lords, may I make one more request? My lords, unfortunately, my lords, when the matter doesn't come up, the respondent is making the mentioning and the petitioner is enjoying the stay, my lords.
Well, this is
No problem. Anyway, whatever.
This is so unfortunate but to make such a statement.
My
So that
lord,
exactly.
No issues there. I mean, let us not join issues there.
Yes, exactly.
Any of you, at least I am not joining issues, so none of you should
my
not
lords, maybe at least get
join any.
the board listing, my
No.
lords.
That you have to
Fresh admission, my lords.
that you have to request to the computer and the DZ and all those things. That is beyond the court's control.
My lords, at least in the fresh admission list, my lords, because this matter
It can
has
be.
not
It can
been
be.
the last 7
The
months.
category, the number can be changed.
Please, ma'am. I bow down.
Category cannot be changed. And if I am dictating it to be category, then I am showing some definitely more indulgence. Then I have to record reasons.
I bow down.
That why I am changing because this is automatic.
Then I bow down, my lords. I
Well,
will
can
not
it be
say
any time
that.
the second week of February, my lord? December, 6th, 7th, 8th, whichever day, my lord.
If since this is saying that there is a stay order, let it come on
My
24th.
lords, we have a bank auction tomorrow, my lords. That's why we had requested for Monday. Now, my lords, this has happened today, my
No,
lords.
that day actually, even I was skeptical because there are times by the weekend, if the file is not getting signed or there is some corrections,
No, my lords, that's why I'm
that's
not
a difficulty.
insisting.
That's just,
My lords, my problem with the longer date is that, my lords, I am...
no, 24th anyhow it is being listed.
24th.
24th is
Great.
listed.
Right, man. 24, no issues, man. 24.
24th.
Right.
Or see, but the Lawrence Senior is saying other than 22nd, even on
Yes, sir.
23rd is agreeable. You are saying 24th.
24th, my lord.
I
Though
know.
the matter was, say, sorry, order ta kharid li. Quickly order.
Well, at least in our High Court, my lord,
Yes.
we will go by a system. When there is a mention to be made in the first hour, my lord, the other side is to be informed. When the other side is appearing.
She didn't tell that. She said that though it was directed to be listed,
But
it has
still-
not been
but
listed.
Still then.
No, prior to that, what happened actually, my secretariat, they informed me that this matter was left out, was not returned.
Yes, ma'am.
After correction, so maybe it was returned Friday. You see the time, there is a cut-off time also. Beyond sending the file, beyond around 5:30 or 6,
Yes.
will not be possible to list it.
Yes, my lord.
The provisional list is published around
Around
6:30.
7:30.
6:37, maximum 7. Even, in fact, many courts it is coming by 6. For my court, it is around 7. So sending the file beyond 6:30 solves no purpose. No one will be there to even
Exactly.
understand what is there in the order and to list it.
So now will I take it for 24th, my lord?
24th, yes, because there is only one line order is to be passed.
Yes. May I take a lot of leave?
And the connected matter was there, or is it the only matter?
Only man.
Okay. On 16/11/2023, the matter was directed to be listed on 20/11/2023. However, as the file could not reach after the court proceeding in time in the listing section, it could not be listed today as directed. On being mentioned by the learned counsel for the opposite party, number 4, upon Mr. Karducho, this is Miss Prachi Johri, MS. Prachi Johri. The matter. No, in fact, no. Actually, she has not mentioned. That's not. She didn't mention.
I was
Okay.
trying to say, my lord.
Yes, yes. She didn't mention.
All of this.
No,
was
no,
decided.
not on being mentioned. The matter was listed thereafter to be taken up at 2 p.m. today. Learned senior counsel appearing for the appearances they have to share. The learned senior counsel appearing for the petitioner that since the matter was not listed in its normal course, he was not aware of this listing, and the matter may be adjourned for further hearing. as paid for list on 24. Appearance sir, she didn't mention actually. When she mentioned that this has not been listed, then I said yes, I have been informed and it will come up in the list.
I'm so highly obliged, my lord. That's what I told my senior also. That
No, she didn't
I'm
mention.
highly obliged.
She didn't mention. So, but somehow I also forgot. In fact, I have dictated that you mentioned.
Extremely grateful for this.
Yes.
my lord. I didn't
Since
mention it.
order is passed, my lord, say interim order to extend.
Interim order, yes, interim order has passed earlier. Shall continue till the next day.
Obliged, my lord.
34.
Madam, मैं कहले अर्जन पर तो
Your name, sir?
Kumar Das, AK Das.
You have a power here. Mr. A.K. Das for the petitioner, Mr. Standing Counsel for the state, the Learned Counsel for the petitioner.
Well, anybody has appeared in this? Is it 376.3 is there? Notice was issued, my lord.
What is your instruction? It has been sufficient.
No, my lord, I don't have the. I have the CD, my lord, bond. Regarding, my lord, sufficiency of notice, I don't have the, my lord.
Okay.
Proper instruction.
A.K. Das, Mr. Standing Counsel. The Learned Counsel for the petitioner seeks accommodation to advance arguments as prayed for list on 8/12/2023. The registry shall intimate the Learned Court in session of the matter. Have you filed extra copy in the registry?
No, ma'am.
And then how it will be not issued? Yes. There is an order. Are you aware of the procedure? There is an order 30th August. You have to file an extra copy in the registry to be forwarded to the Learned Court in session of the matter.
So it is not in my knowledge, sir.
Okay.
That senior is conducting this case.
You are very senior also. Don't say that senior is conducting. It is for this. It is submitted by the Learned Counsel for the petitioner that due to inadvertence, extra copy of the brief has not been filed in the registry, which shall be filed. How much time you require?
15 days.
15 days upon the copy serve, it should be dismissed right now.
Copy serve, I will be tomorrow.
The disoriented hontuni.
Sir.
Don't be, I mean, the panic of the magile adjournment diya. When this earlier order has not been complied, I have to look at that. Had been not been served and within 2 days, within two working days in the registry. Registry, upon receipt of the extra copy of the brief, shall forward the same to the Learned Court in session of the matter, who shall do well to intimate the petitioner, intimate the informant oblique victim through office of the court regarding the right of audience in the present proceeding. The Learned Secretary, Legal DLSA shall also be informed to engage counsel through the legal aid on behalf of the informant oblique victim if they are unable to engage counsel on their own. The next date of the listing shall also be intimated. The Learned Counsel appearing through legal aid, the Learned Counsel appearing for the petitioner, informant oblique victim shall have the may appear through the nearest virtual courtroom of the High Court of Orissa. It is submitted by the Learned Standing Counsel that he has not received intimation.
Case diary received, but the intimation.
He has received case diary. He has received case diary. He shall also again intimate the concerned IIC to inform the informant oblique victim regarding the right of audience in the present proceeding. Yes.
Date kindly.
Date of date 8th of December.
Obliged.
Next, please.
37.
Mr. Bharat Bhushan Rautray for the petitioner, Mr. Standing Counsel for the state.
But on the last occasion given the affidavit, the one case is pending against the petitioner, that was 2016. And 302 he has not been charged sheeted. I given the copy of the charge sheet.
What 26 रो केस कोन करिवे बोली आगु डिसाइड करछन्ते ना कोन एफिडेविट रे लिखछन्ते
Yes.
5/10/2026 रे मु केस करी बोली लिखछन्ते पेज 2 रोमान 2
Second case.
26. I'm sorry.
बेल केमती दिया हुआ जे एफिडेविट दे मोर केस करिवार अछि
पुनी 302 केस
302 रे करिवे आपण 294 302 34 रे करिवे
देखि ना सेव दैट
the affidavit has been filed by the petitioner on behalf of the petitioner through
your mother
through his mother, indicating the past allegations of criminal activity. The copy of the affidavit has been served on the learned standing counsel, who submits that इथिरे जोडा एबे जोडा करचंदी जोडा पेंडिंग अछि सेते कोन मैक्सिमम पनिशमेंट कोन
506 317 325 323
नहीं बर्तन डाउ जो 21 बी एनडीपीएस मतलब 109 ग्राम्स ऑफ ब्राउन शुगर
बर्तन नो 20 109 ग्राम्स ऑफ हीरोइन
ऊपर तो से लिखा है आपण हठात कोन 5-6 कहले मु से
नहीं जो क्रिमिनल केस पेंडिंग अछि गोटी से अछि 500 16
कोन लिखले in the said affidavit it is submitted it is submitted by the learned counsel for the petitioner that there is an inadvertent typographical error in page 2 first line. The year has been mentioned as 2026 instead of 2016. He seeks to correct the same. Prayer is allowed. The correction be carried out after putting the initials of the learned counsel. The learned counsel shall put his initials after making the corrections.
I'll do it.
Then para. It is submitted by the learned counsel for the petitioner that the petitioner is in custody since
4/8/2023, my lord.
4/8/2023. The final prosecution report has been submitted on
That I don't.
on so and so date. Considering the period of incarceration, considering the period of incarceration, the petitioner may be shown indulgence. 29/9/2023, considering the period of incarceration, the petitioner may be shown indulgence as far as the prayer for bail is concerned. But it is submitted that no other past allegations against the petitioner as far as the similar offense under NDPS Act is concerned. Though there are cases pending against the petitioner where trial is continuing, as indicated in the affidavit. It is submitted, the petitioner shall submit himself to the jurisdiction of the learned court in session of the matter and shall abide by all terms and conditions that would be imposed for grant of bail. The learned standing counsel, referring to the materials contained in the case diary submitted by the investigating agency and referring to the section 37(1) of the NDPS Act, opposes the prayer for bail. Initial कर दियो डेट
कर दीजिए नेक्स्ट
सेटा परे 27 हे जो आपण 26 टा करेक्ट कले 16 सेटा 27 मसे रे करेक्ट हो opposes the prayer for bail. Having heard the learned counsel for the petitioner, the learned standing counsel for the state, and considering the material on record, this court is inclined to grant bail to the petitioner subject to such stringent terms and conditions that would be imposed by the learned court in session of the matter, which shall also include a condition that a family member of the petitioner shall stand surety. Then second condition, any violation of oblique deviation from any of the terms and conditions that would be imposed shall result in filing of petition for cancellation of bail by the law enforcement agency, oblique informant, oblique victim. Disposed of accordingly. Mr. Tara Prasad Mahapatra for the petition.
May I please Lordship, my lords?
Standing counsel for the state. Yes. 307, you have any past allegations against you?
My lords, 307 allegation against 307, my lord, simply injury, simply in nature.
No criminal.
The learned counsel for the petitioner submits that. Se kyun tangar koya katha koile? Apon koile kon ho?
Sorry, my lords.
The learned counsel for the petitioner submits that the petitioner is in custody since
7/7/2023.
7/7/2023. The final prosecution report,
yes,
has been submitted on
21/10/23.
21/10/2023.
My lords.
Considering the period of incarceration, the petitioner should be shown indulgence as far as the prayer for bail is concerned. Subpara, it is further submitted, the petitioner being a local person, he shall submit himself to the jurisdiction of the learned court in session of the matter and shall abide by the terms and conditions that would be imposed for grant of bail. Learned standing counsel, referring to the materials contained in the case diary submitted by the investigating agency, opposes the prayer for bail. Stop. However, it is not disputed as contended by the learned counsel for the petitioner that there is no past allegations of criminal activity against the petitioner, as per the police, as per the report furnished by the investigating agency. The learned counsel for the petitioner also submits that the injuries suffered by the injured are simple in nature and the health condition of the victim is good. Para. So the petitioner का submission टा गोटे जार करते हो तोड़ा पर है. The having heard the learned counsel for the petitioner, the learned standing counsel for the state, and considering the material on record, this court is inclined to grant bail to the petitioner subject to such terms and conditions that would be imposed by the learned court in session of the matter, which shall also include a condition that violation of deviation from any of the terms and conditions that would be imposed for grant of bail shall result in filing of petition for cancellation of bail. Disposed of accordingly.
Item 39.
Yes.
May I please, your lordships?
Yes, please.
The petitioner has surrendered 16/11/2023. Tomorrow I will file surrender certificate.
Your name, madam?
Tomorrow.
Apanko na ta?
My lord.
Apanko na kono?
Anita Rani Panda.
You have power here.
Yes, ma'am.
Miss M.S.A. Panda for the petitioner, standing counsel for the state. Learned counsel for the petitioner submits that in terms of the order dated 18/10/2023, after expiry of the period of interim bail granted, the petitioner has surrendered on
16/11/2023.
16/11/2023. Some further time may be granted to furnish the certificate public order indicating surrender of the petitioner. How much time you will require?
Let it come tomorrow.
As prayed for. No, you want for final hearing of the bail.
My lord, this matter can, my lord, since the bail it is a bail jump, my lord. He was there in the bail, my lord, and thereafter, my lord, jump. My lord, that bail application is 9/44/2018. That has been disposed of on 9/1/2019. It will go before that bench, my lord.
Obviously. Okay. Since the present case arises out of,
my lord, may kindly verify, my lord, that record.
Eta pradhani janire asuni je, kintu High Court rule अनुसार सेठी जिवो.
Yes.
Honorable judges still in service बोले जो देती हो ना knowledge है पे आपन को
देखिए उड़ियो.
हाँ जी.
देखी देले बारीक उठे देखी दे. 944 टा के डिस्पोज.
दा 944 आसी. Asini. Yes, I marked that list. No other case is there. Okay, Dr. Khabisra.
Then you do.
ଆପଣ ଯଦି ଏବେ interim bail ରେ ଆସିଛନ୍ତି ତାହେଲେ ଟିକେ ସମୟ ନିଅନ୍ତୁ. Usually if you mark the practice here, it takes some more time. କାଲି ପାଇଁ ରଖନ୍ତୁନି. There is a possibility କାଲି reject ହେଇଯିବ, ଲାଭ କଣ ହବ ତାହେଲେ? କଣ ଲେଖ? List on first week of December कर दियो. 5/12/23.
My lord, may I kindly call for the stage of the trial, which is 2015 matter.
The city case, the registry shall obtain the up-to-date status of trial in city case number 126 of 2015 in connection with Machakunda PS case number 64 of 2015. ये सेक्शन कौन थी लगी?
NDPS.
Yeah. Yes, next.
40. On behalf of Mr. Sahoo, LLC may permitted to place.
Yes.
The last
Mr. Baral, SK Baral on behalf of AK Sahoo for the petitioner. Mr. 376(1) notice is not necessary.
No, Malas.
Not.
Case diary is there.
Yes.
Mr. Standing counsel for the state. What is the age of the accused?
Accused is 23 years. Victim is 26 years. As for FIR. 160% statement of lordship periods. There
Page 22, the statement, my lord, your lord, to
the sister-in-law.
Sister-in-law.
So there is a possibility that it may be circulated. You obtain that, Mr. Baral for the petitioner. Considering the nature of allegations made in the FIR, and after going through the case diary produced by the lauded standing counsel, it is directed. The standing counsel shall obtain specific instructions regarding the objectionable material, whether still being there is a whether there is a possibility of the objectionable material being circulated in any manner into any social media format. How much time, Mr.
10 days.
As the list on today's 17th, 20th. List on 4th of December.
My lord. Hon'Ble.
41.
I pray for an adjournment.
Mr. Gyanananda Ponda for the petitioner, Mr. Standing counsel for the state. Notice is not necessary. 376(2)(n). The learned counsel for the petitioner, 6 for adjournment, 6 for further adjournment. As read for list on 13th of December 2023. The Lawless Standing Council submits that
CD is there.
CD and 164, he has received the case diary along with the statement of the victim recorded under section 164 CRPC. Yes.
42.
Highly urgent.
Miss M.S.D. Behura for the petitioner, Mr. Standing Counsel for the state, the learned counsel for the petitioner seeks a further accommodation to advance arguments as prayed for list on 14th of December 2023. The learned counsel for the learned standing counsel submitted that case diary is available.
Yes,
along with the statement of the victim recorded under section 164 of CR.
Well, trial has started. In the meantime, the victim must have been examined in the meantime because it was posted to some 8 or something.
She is not taking initiative.
Yes.
What can be done?
Yes.
Item 42, 43.
Let's see, 43 and 44. It's a transfer brief, Lordship.
Your name, sir?
P.K. Malik, Lordship.
Mr. P.K. Malik. You are appearing in this case?
Yes, my lord.
So P.K. Malik for the petitioner, Mr. Standing Counsel for the state, learned counsel for the petitioner submits that he has been entrusted with, along with his colleagues, to appear in the matter after retirement of the counsel who was appearing earlier. This the learned counsel seeks further accommodation to advance arguments as prayed for list on 15th December 2023 to grant further opportunity to the petitioner. The learned standing counsel submits that case diary has been received.
Yes.
Yes.
Number of 5 witnesses are there.
Yes. So tapar outre change hai.
44.
So
44 is also
more the merrier. 44 same appearance, the same FIR.
Yes.
Yes, ma'am.
Yes.
45.
I have also same prayer, my lord. I am paying for time, my lord.
Amuliratna Panda.
CD is also not there.
Amuliratna Panda for the petitioner. Mr. Standing Counsel for the state, learned counsel for the petitioner seeks accommodation to advance arguments as prayed for list on 15th of December 2023. The learned standing counsel shall obtain up-to-date case diary.
Yes.
Oblique instruction. Yes.
46.
Mr. Gyanananda Panda for the petitioner.
In this case, my lord, I am unable to contact the family members of the petitioner.
The affidavit has not been filed.
No.
The Mr. Standing Counsel for the state.
I beg your pardon, my lord. From lower court advocate, I have taken instruction that the petitioner has been detected HIV positive inside jail. Lordship may call for that status report from the jail.
No, unless you get something, you hear something, how can I? And you have to specific that health condition and this this treatment ART, antiretroviral therapy, is best available in government. It's not available privately also. So he has to be provided. But you have to give me something.
No,
Some affidavit, something. So
document.
you see, then what will happen? I'll be, ordering 2 contradictory orders. First, that Mr. Panda submits that he has no instructions from the petitioner relatives. Then I will dictate. The learned counsel for the petitioner submits that. Then how the 2 things will coexist? If they are able to contact you, then why the lower court counsel, they should more the reason contact you.
Affidavit can be filed by the
affidavit or whatever, but the learned counsel for the petitioner seeks further accommodation regarding to comply with the order dated 14/9/2023 for filing affidavit on behalf of the petitioner regarding the past allegations, if any, regarding criminal activity. As prayed for list on 18th December. Yes.
47.
That matter was there on Friday. My lords required that CD should be brought in another case. That CD was there. My lords already granted bail to the main accused person. He is also in custody.
That Bhubaneswar matter, you said.
Yes. I'm verified.
The main co-accused person, my lords, have granted bail.
Mr. Dayananda Mahapatra for the petitioner. Mr. 8976 ACH. Here they have now at least 89 sorry, Dayananda Mahapatra is standing counsel for the state. And counsel for the petitioner refers to the earlier order dated 5/10/2023 passed in BL APL number 8976 of 2023, wherein the bail was granted to one Gulo alias Prabhat Kumar Martha, who is stated to be the main accused.
What activities?
In the case, in the Lakshmi Sagar PS case number 263 of 2023, corresponding to city case number 591 of 2023. The learned, when the matter was last taken up, the learned standing counsel, the learned standing counsel has also obtained instruction that the BL APL 8976 and the present BL APL arise out of the same PS case number and corresponding city case number. In view of the above, the court is inclined to grant bail to the petitioner subject to such stringent terms and conditions that would be imposed by the learned court in season of the matter. We shall also include a condition that any violation of oblique deviation from any of the terms and conditions imposed for grant of bail shall result in the filing of petition for cancellation of bail by the law enforcement agency, disposed of accordingly.
Lordship, on behalf of Learned Senior Counsel, the SK Padhi, kindly adjourn this matter.
Here the leave has been granted or not granted?
Only on limitation.
Limitation has been, notices have been issued.
Yes, my lord.
Yes, it is yet to be
condoned.
So you just verify the deposition and.
Yes, my lord.
Mr. Standing Counsel for the state, you have been served with a copy. This case, copy you have been served. No idea.
No ideas.
Apanako naata?
Itisri Maharana.
Miss Itisri Maharana on behalf of the opposite party. The Learned Standing Counsel shall go through the copies of the depositions apart from his submissions made in support of the prayer for condonation of delay. To apprise this court regarding merits of the case. The Learned Counsel appearing for the opposite parties seeks accommodation as prayed for. List on 18th December.
Okay, sir.
Yes.
49.
Petitioner none. Hybrid board lekhutive. Petitioner none. Opposite party blank. The learned none appears for the petitioner when the matter is called. The office note put up by the registry indicates that requisites have been filed late for issuance of notice, which are on record, which are kept on record. Let notice be issued to the opposite party as directed by order dated 27/6/2014 by registered post with AD, list after SR. Yes.
50.
The notice issued afresh. You now obtain the correct address, then it will be listed.
Fresh steps in correct
So,
address.
no, I'm not directing again issuance of notice because there's no point. Again, it will be returned unserved.
Yes.
You simply obtain instruction. Then there's point in issuing notice. In fact, the earlier matter, Mrs. Mira Ghosh, she has passed away.
Address he has left.
Yes. So that's not the correct address. Since the notice issued afresh has been returned unserved with a postal with a report from the postal authority, quote, address he left. The Learned Standing Council seeks accommodation to obtain the present correct address of the opposite party number 4 and prays for further 4 weeks time. Prayer is allowed. List January ode list kar diyantu.
Actually, the matter was listed earlier.
Apna notice nele, afresh notice nele.
My lord.
Tapare se feri aslani authare.
My lord, may I know the exact date of return because we got the instruction, my lord, the correct address on 29/9.
Now it is November. This is almost 2 months ହେଇଗଲାଣି ନା ଆପଣ ନେଲା ପରେ ତାପରେ ଯାଇଛି ଆପଣ କହୁଛନ୍ତି ଯେ ଆଗରୁ ନୋଟିସ ଯାଇ ନଥିଲା ନୋଟିସ afresh ଯାଇଛି
Yes, my lord. Earlier it was also direct.
କେତେ ନମ୍ବର ଆଇଟମ
50.
50 ଆଇଟମ
49.
50 ନା
50.
49 non appearance ହେଲା ଆପଣ ମିସ୍ କଲେ
50.
This is serial LP 58. Yes, I am looking at the correct brief. Now checking whether I am looking at the correct brief. Yes, you are right. On 4/12/2018.
4/12.
ନା କେତେ ଲେଖା ହେଇଛି ନା 23 ଲେଖା ହେଇଛି 16/11/23 16/23 ଆପଣ ନୋଟିସ ପଠେଇଥିଲେ କେବେ 18 ରେ so you obtain
My lord,
you have taken notice twice. It has been returned. If you can obtain any present address,
Yes,
then let
sir.
us see. Or in one case, the person had died actually. I don't know what has happened because mentioning that whether he's dead or alive, that doesn't look good.
Yes, my lord.
Sounds also doesn't sound good. Welfare of the victim or something you obtain. 4 weeks पर उन्हें date कर दो.
Yes, sir.
10 January 2024.
Yes, sir.
It was issued on 14/11/2018.
Because we got the instruction, my lord, on 29/9/18. I think
So 29/9/18.
29/9/18.
So thereafter notice has been
There are
issued.
notice, my lord.
Yes. So that has been returned unserved.
That hasn't. Now it will be difficult.
So we'll think if in case you are getting it, then let us then we will see.
My lord. My lord, so may give us 3 weeks time.
4 weeks I have granted.
Yes, sir.
So it goes beyond vacation.
Obliged.
Take it.
51.
IA 53 of 2023. The IA has been filed for condoning the delay in filing the petition. Delay delay of 43 days in filing the petition. Hard Learned Standing Council for the state. Issue notice and admission. It issue notice. Issue notice by registered post with AD to the sole opposite party, subpara. Requisites for issuance of notice be filed within 3 weeks. in the present correct address.
Yes.
52.
That report has not come in. Sorry.
Let us await report.
Yes.
The 52 lekhibe. A petitioner none, Mr. Standing Counsel for the State, opposite party. Registry has put up a note indicating that the status of the up-to-date status of the ST number 493 of 2004, earlier pending before the ad hoc additional session judge, comma, F.T.C. Athagada, has not been received. Para. Registry shall do well to obtain the up-to-date status of the case by the next date. List on 5/12 na kebe? 5/12. 5/12 Yes.
53.
53.
Petitioner none. None appears for the petitioner when the matter is called. Though the matter is pending since 2011, steps for removal of defects as pointed by the stamp report has not been taken. To grant further opportunity, list on 4th of December 2023. Yes, next.
54.
Same order. Petitioner none. The defects not removed. Yes.
Same date.
Same date.
55.
Petitioner none. No steps have been taken for conversion of the petition to CRLA as per the staff report. To grant further opportunity, list on 6/12.
56.
Gyanananda Panda thile tor palaje kono. Petitioner none, opposite party blank. None appears for the petitioner when the matter is called. To grant further opportunity, list on. Acha, it is repeated. Repeated. ते कौन लिख ले? नहीं सीधा आप तो सीधा लिस्ट जोड़ा लिखले शेडू काटी ता पूरा लिखो. Non appears लिखले ता परे लिखिबे. None had appeared for the petitioner when the matter was last taken up on 16/10/2023 and the matter was adjourned to grant further opportunity to the petitioner. Though the matter is pending since 2011, after issuance of notice, no further steps have been taken by the petitioner. Apparently, the petitioner has lost interest in prosecuting the matter. The petition stands disposed of. Yes, next.
57.
None appears for the petitioner when the matter is called. By order dated 4/4/2014, the defect was directed to be removed. That is, as per the staff report, the nomenclature of the case has not been correctly furnished. Which should be CRLA under section 372 into bracket proviso of CRPC. though the matter is pending since 2013, no steps have been taken by the petitioner after filing of the petition, nor the defects have not been removed. The correct nomenclature has not been followed while filing the petition. Apparently, the petitioner has lost interest in prosecuting the matter. The petition stands disposed of. Yes, next.
58.
Petitioner none. Opposite party blank. When the matter was listed for the removal of defects before the deputy registrar on 17/7/2014, for removal of the defect as pointed on 29/6/13 by the staff reporter, the matter was referred to the bench for dismissal of the matter, as the defects have not been removed for more than a year. Thereafter, no steps have been taken on behalf of the petitioner. Apparently, the petitioner has lost interest in prosecuting the matter. The petition stands disposed of. Yes, next.
59.
Petitioner none. Opposite party blank. None appears for the petitioner when the matter is called. Notices were issued by order dated 8/7/2013, directing to file requisites for issuance of notice by registered post with AD. And the impugned order was stayed with a condition subject to payment of rupees 50,000 by the petitioner to the opposite party. And the perusal of the office notes, it is indicated that the requisites for issuance of notice were not filed, nor the order dated 8/7/2013 passed in miscase number 729 of 2013 for payment of the amount to the opposite party has been complied with. Thereafter, no steps have been taken. No steps have been taken after 8/7/2013 on behalf of the petitioner till date. Apparently, the petitioner has lost interest in prosecuting the matter. The petition stands disposed of.
60.
May please your lordship. Item 62 up to 64 minutes.
You take notice of this?
No,
I'm extending the time.
But
3 weeks.
I have a submission for lordship.
Yes.
For lordship consideration. These are the 5 matters pertaining to 2014. But may I suggest, all these notings pertains to the defects indicated by the registry. Let the defects be ignored. All the 5 matters taken out tomorrow for admission.
No, sir. Here, what has happened? Already there is an order issuing notice. I can't modify that.
My second alternative submission, if lordship is lordship may dispose all the 5 matters as per the orders. As a lordship dispose item number 40. That's 51 some J.N. Panda, 56 matters. That despite orders.
What has happened? Maybe they're lenient towards state.
No, even the opposite party will not be prejudiced.
No, I understand.
They will not be prejudiced. Tomorrow it will be taken off for final disposal. Because all these cases are coming off. My predecessor, they have filed it without filing the requisites. Now I spent I spend all this thing for filing requisition every day. It's around 500 to 700. So every day I spend.
Opposite party blank. The learned the office note indicates that though notices were issued on 21/9/2015, requisites were to be filed by 25/9/2015 for issuance of notice to the opposite party. No steps have been taken.
That was the
After the state order.
Lordship
Thereafter, the London Standing Council has entered appearance on 14/11/2023. You have appeared much after that. So even maybe it was not within your knowledge also. But anyway, it has not been filed. Since the matter is pending since 2015 after issuance of notice on limitation, the court is persuaded to go through the apart from considering the matter for condonation of delay. This court text also has gone through the judgment impugned as annexed to the petition. On perusal of the judgment, subpara, it is indicated that the learned court has relied on the evidence of the prosecution witness has examined in detail the evidence placed by the prosecution, that is the PWs 1, PW2, who was the accompanying witness, PW1 bracket likhe complainant, PW2 accompanying witness, and have failed that. The prosecution has failed to bring home the guilt of the accused beyond all reasonable doubt. Apart from not condoning the delay in filing the petitions, in considered opinion of this court, this is not the case. The present case is not fit where leave can be granted to appeal. The petition stands disposed of.
May I submit one
Yes,
line?
yes.
Lordship, may I add one line? The submission of the State Council doesn't stand to the scrutiny of law, and because the impugned order doesn't suffer from the factum of perversity warranting any interference.
Mr. Das, that I was telling you from the beginning. Here, actually, after issuance of limitation notice, I am not considering that.
I would draw my
So suppose if it would have been sufficient then I would have noted your submission. I have not gone to that stage.
I withdraw.
Yes. No, not. I mean, not that way. But since perhaps it has to be dismissed on limitation.
Then
but since I'm also because I have to record that, I have also looked at the.
But still, I may submit one thing, my lords, because whatever the judgments I have gone through, my lords, always only one aspect is being considered before granting leave or rejecting leave is a factum of perversity. That what may be present to service.
So since there is no, I'm not
because the Supreme Court said
I cannot go into the merits, strictly speaking. 2015, the limitation notice is issued, and in 23, after 8 years, still no notice is taken.
So accordingly, CRP is disposed of.
Yes.
Same thing, my lord.
Same. So basically, initially, as you said, I can again after 8 years, you can take notice in limitation, which which I am not permitting.
Yes.
Because it has been noted by that, but the defect has been removed. After removal of defect, it was placed before the regular bench. Notices are issued on limitation. No requisites filed in all these matters.
But I'm grateful, your lordship, find out the date that everything happened before my appearance.
No, because it is apparent. Because even you do not know what has happened.
Because my predecessor there did everything without finding this requisite.
No, let us not. I mean,
because that
the notices have no steps have been taken. Yes.
65. 65. It's a petition to do.
65.
Simpson Jena.
Mention kortile. 2 weeks time nale. Nahin. Mr. Simpson Jena, on behalf of B.K. Das for the petitioner, Mr. Devasis Naik AGA for the state, Learned Counsel for the petitioner submits that due to inadvertence, the nomenclature of the petition could not be changed, though it was pointed by the stamp report. It is for the Learned Counsel prays for further time to do the needful as paid for further 2 weeks time granted. Yes.
66.
My lord, in this case, it is not returned back, my lord.
Anything survives? What is the nature of litigation?
138 NI Act, my lord. I am appearing for the complainant.
Yes.
The matter was transferred to different courts, my lord. But my knowledge is not there. That is why I have filed one application before the CGM and could know that the matter was dismissed for default and acquitted the accused person. And before your lordship, my lord, yesterday I have
so what can be done after so much of time? Dismissed for default. This is already 5 years have passed in this court. So prior to that, the cause of action is of which year? 2016.
2006, my lord.
17 years. 1 CC 2010, 13 years.
My lord.
See, complainant has never appeared.
2010, my lord.
You see the order sheet, complainant, when did he appear?
My lord, because that matter is transferred to different court, my lord.
I could not get you. I could not get you. What do you mean by it? You see, this order is by the only single judge, JMFC Kotak.
My lord. Your lordship may see.
You see, 8th of February, it starts with 8th of February.
My lord.
And how many dates he has remained absent?
My lord, your lordship may see page 8, annexure 1. I have filed one application before the Chief Judicial Magistrate because that matter was transferred from different court, my lord, and a date was advanced on dated so and so, and no date is advanced. That is why I filed one application before order annexure 1.
I am not getting. Sabuda order to JMFC kale. ट्रांसफर कौन है कोठी गेला सेटा मते क्लैरिफाई करंतु
सर प्रथम कथा है जो डेट रे से जो ट्रांसफर कले तीनटा कोर्ट को ट्रांसफर कले गोटे कोर्ट डिफॉल्ट है
आपण सुनंतु कोर्ट नाटा मते कोंतु आपण तीनटा दीटा कहले मु कोनटा बुझी
एनेक्सर 1 रे सर लिखि एनेक्सर
पेज
1
केते
पेज होची 8
आपण आपण सेटा अवॉइड काई करछन मु जदी पचारुची आपण से पेज टा को टर्न करनांती काई की
कोटा
1cc 1026 of 2010 1cc केस रे जो ऑर्डर हिची आपण जस्ट मार्क द ऑर्डर शीट
आगे
पेज मार्क 10 बोधे सेटा पेज 10 हबो हां पेज 10 ऑफ योर ब्रीफ देखो सर्टिफाइड कॉपी अछि
आगे
इट स्टार्ट्स द ऑर्डर देखंतु 8/2/16 रो आरंभ हो गेला
11/1/16
11/1/16 रे कंप्लेनेंट एब्सेंट
तापरे 8/2/16 रे हाजिरा देई
नहीं आज्ञा कंप्लेनेंट एब्सेंट
सर 8 देखो सर केतुटा कोर्ट ट्रांसफर हिची
8/2/16 रे कंप्लेनेंट एब्सेंट
सर तापरे
देखंतु 10/5/16
हां
कंप्लेनेंट एब्सेंट
एटे सर ट्रांसफर हे चालुची मु केमती जानिबी सर गोटे कोर्ट रे से दिया होची हमरो हाजिरा किंतु आमे टाइम पिटिशन पठौछु किंतु सेथरे नाही
कोठी ए जो मैटर टा unless you show that it was not pending before the JMFC then how your argument will survive
सर जेतेबेले गोटे तीनटा कोर्ट ट्रांसफर गोटे मासे रे सर गोटे मासे रे तीनटा
आपण सुनतो आपण ऑर्डर शीट न देखि कि कहै छै
नै मु सर ऑर्डर शीट
आपण एथिरे को डेट रे
हां
JMFC ग पाखरे केस ता नथिला से ऑर्डर कर देले सेटा कहिबे ना
आगे
कि को डेट रे एवं कहिबे जे JMFC कटक पाखरे केसटा नथिला JMFC रूरल का पाखरे थिला JMFC 3 का पाखरे थिला JMFC सदर का पाखरे थिला दैट यू हैव टू बी स्पेसिफिक
आया एटा सर मु एनेक्सर 1 रे लिखि
नै नै आपण ऑर्डर शीट रो मत देखंतु फॉरवर्ड शीट मु अन्य आडे दले केमथि होबो
ऑर्डर शीट रे सर
आज्ञा JMFC गोटे कंटीन्यूअसली ऑर्डर शीट से सिग्नेचर कले तो आपण सर्टिफाइड को भी प्रोड्यूस कले
कोटे रे
जो पेज 10 रे
हां
आपण एंड इट इज स्प्रेड ओवर माने अक्रॉस सेवरल मंथ्स सेवरल डेट्स
सर मु कहूची सर एटा तीनटा मैटर थिला सर गोटे पयरे तीनटा मैटर थिला
आपण सुनंतु आपण जेतेबेले सर्वनाम रे कहउचंती तीनटा मैटर दीटा कोर्ट मु किछि बुझी परनी
नै नै
आपण मते 1cc नंबर 1026 ऑफ 2010
हां
जो ऑर्डर हेची सेथिरे JMFC को पाखरे केसटा नथिला JMFC रूरल का पाखु पळैथिला सेटा मते स्पेसिफिक कोंतु
सेटा सर आगो हला
फर्स्ट ऑर्डर देखले 11
ही शर्मा देखन सर
अरे आपण ना कोंतु 11/1/2016
हां
11/1/2016 रे JMFC ऑर्डर टा केमती हला जदी नथिला ताका पाखरे
JMFC रे थिला
आज्ञा
तापरे आसिला 10/5/16 रे पुनी ट्रांसफर हेकी पळे आइला
नै
10/5/16 पेज ता परटा 11 पेज रे
नो नो
सर फास्ट
आपण 8/2 रे छाड़ देले
8/2 रे थिला सेडी
आपण 11/1/16 रे आ 8/2/16 रे आपनकर नॉन अपीयरेंस
सर सेतरे सब हाजिरा दिया हिची किंतु सेतरे
सेटा आई कांट गो बिहाइंड द ऑर्डर शीट I cannot go behind the order sheet that though Hajira was filed, it was not noted by the learned magistrate. That is not proper. And more so for a court which is having an administrative jurisdiction over a lower court. That you have to file a petition there on that day itself.
Sir, recall have provision nahi sir.
Whatever. Upon a petition file karthante. I cannot go behind the order. जे Hajira was filed and it was ignored.
No, your lordship may keep it some other day.
Then आपण देखंतु 10/5/16 रे
आगे
पणकर this court is case record is received on transfer from the court of Sri S Rana
आगे
JMFC Kotak
आगे
so and taken up to my file then 10/5/16 16/5/16 17/6/16 29/6/16 16/7/16
आगे
and again on 27/7/16 it continued in that court
sir se ame ei court re dei chalchu ame janinu sir eida ho kote
problem hela je that you should have filed a petition there apno earliest kebe petition file kale jo कहउचंती kebe file kale
eida file करछि sir e jetobale date न देले तापर फाइल कली एटा 14/12/17 फाइल कली annexure 1 जेमती डेट गुरा किछि एपट मिललानी कि सेपट मिललानी सेठी जाई देखला बेलकु सेठी भी मिललानी तापर पुणी ट्रांसफर हो जाई
आपण सेटा भी पेयर करना है आपण प्रेयर अलग कथा लिखछन आपण लिखछन जे सिमिलर केसेस आर पेंडिंग सो इट शुड बी ट्रांसफर्ड टू ए पर्टिकुलर केस आपण को लिखना है जे you see most likely the lawyer also got confused or the petitioner got confused तीनटा केस हेची तीनटा जगह रे लिस्ट हेची तीनटा रे माने तीन जण सो सेतिरे that doesn't support your case
नै मु सेथरे सपोर्ट मु मागुनी सर मो कहया कथा होची दीटा कोर्ट को जो ट्रांसफर हैला प्रथम हैला हम जानि बेलुनी तापर से कोर्ट को आसिला बेलकु से आ गोटे कोर्ट को पळैलानी
सिमते आपण कोहंतुनी
सर एटा
प्रथम कोर्ट ए कोर्ट से कोर्ट कोहंतुनी आपणकर जो आपणकर फास्ट ट्रांसफर पर कंटीन्यूअसली हैव रिमेन्ड एब्सेंट फास्ट कोर्ट रे आपण को प्रेजेंट थिले
नै फास्ट कोर्ट रे थिली सर एसडीजेएम कोर्ट रे थिला से ऑर्डर शीट आसी
आपण टिके जेएमएफसी देखंतु
ऑर्डर शीट सेडा आसी
160 ऑफ 1026 ऑफ 2010
आज्ञा
आपण जेएमएफसी जो थिले सेते बेले एस राणा
ऑर्डर शीट आनी ची जो दिन ठारू ए ट्रांसफर हे की आसी ची एब्सेंट हे की आसी मोर 2010 रो मैटर एसडीजेएम कोर्ट रे थिला सब बेले तापरे सी जो ट्रांसफर करी गले तापरे से ट्रांसफर रो आउ गोटे कोर्ट को ट्रांसफर हो गला एठू गला बेलकु सेठी की तापरे सर फाइल सब बंधा हे की थिबो किछि जणा पड़े नै म से दीटा केस रे सर
एस राणा को पाखरे परे जो कोर्ट आसला सेथे आपण अपियर जमा करिना
ना मु अपियर करने मु सर कहू जी मु अपियर करने कारण मु जानिनी मो नॉलेज रे नै मु एकु चीफ जुडिशियल मैजिस्ट्रेट को पिटिशन देला परे सेठू बाहरिला तांकर फाइल सब सर बंधा हे की थिला फाइल सब बंधा हे की थिला खोला हे की तापर पुणी माने संगे संगे जणै देले आगुरु जणौ नथिले से सब कोड डिफॉल्ट हे गला नै एठी नै
आई कैनॉट मोर किछिटा तो आईडिया अछि जे आपण जानि पालेनी सब डेट 12 टा ठीक हे गला
मिछ गयबारे सर दीटा केस रे
एटा
2010 रु पानी नै सर 2016 रु आनी
मिछ सत कथा नै आई कांट रीड बिटवीन द लाइंस ऑफ द ऑर्डर I cannot impute motive to a judicial officer.
Sir, এটা রক্ষি থান তো আউদিন
আপন it may be a mistake of the lawyer. সেটা আউটা জিনিস that's
sir মানুছি মোর কারণ যে আমি ক্লার্ক উপরে ডিপেন্ডেন্ট হলু সিআসি কইলা আগে নাই ফাইল নাই
any transfer is by order of the court also.
Sir, court
and more so it is in the knowledge of the advocate's clerk. They know it.
से सर से
आपण जोटा को सुनंतु पोस्टिंग डेट रे आपण गोटे कोर्ट को गले जेएमएफसी रूलिंग कोर्ट को केसटा ट्रांसफर हे से हाजिरा रखिबेनी
ये हाजिरा दे दे पळे से
सेटा सेटा दे कांट ब्लेम आई कांट इट्स नॉट डन
आ गोटे डेट थाउ
आई हैव टू ऑब्जर्व दैट क्लियरली आपण किछि पिटिशन ने किछि नै ऑर्डर सेट रे किछि नै सेटा सी तांकर से दियंती कि नै भगवान को जणा आपण जो कोर्ट को गले से रखिबे केमते सेटा को से करिवे कोन ताकू तापरे हाजिरा दियंती ऊपर ओळे जे कोन करंती
सियाउ सर देखिनी कहिनी
ठीक अछि माने मोर विशेष अभिज्ञता नै किछिटा अभिज्ञता एवं अंडरस्टैंडिंग अछि
सर जेबे भी जाईथिली मु 3 थर जाईची से फाइल मुळुर बंधा
12 टा डेट रे से हाजिरा देले कोटे कोर्ट रे एवं किछि डेट पाइलेनी एंड गोटे इमीडिएट भी नो जनवरी मास आरंभ होईची सॉरी मे मास रो आपनकर वेंट ऑन टिल डिसेंबर 7 मास काल से दैचंदी
सेटा सर मो मिसफॉर्चून मु निजे जाइनी बेली सर एटा आ गोटे दिन को आसु मु सर
ठीक अछि इट डजंट इंप्रूव एनी डजंट कट एनी आइस पण जो प्ली नै चंदी सेटा आपण कोन आथरे फ्रेश नोटिस नेबे
एटा दिथर जाईची बधे
अतल कोन हो त सेटा को कोर्ट रिस्पांसिबिलिटी ना कोन सफिशिएंसी जदी हेनी नले अनसर्ट नोटिस आसीबो
ने आंसर उड आसीनी सर
एग्जैक्टली नॉट रिटर्न
तो आउ थरे गोटे थर सर दे दल सर एटा ये सीआरएलपी मेंटेनेबल नुह मु काली देखुथिली मोटे कन्वर्सन एप्लीकेशन रे फाइल करी
एने सेटा आफ्टर इश्यूएंस ऑफ नोटिस मु सेटा अलाउ कर परियो इट हैज टू गो टू दैट बेंच आई हैव नॉट इश्यूड नोटिस हियर ଆପଣ ଯଦି କନଭର୍ସନ ଚାହିଁବେ ତାହେଲେ ସେଟା ଏଟା ଲୋକ ଅଦାଲତରେ ବି ଏଠି ଆସିଛି କି ଆଟେଣ୍ଡ କରିନାହାନ୍ତି?
ସେ appear କରୁନି ଆର ଦିଟା କେସରେ
Limitation notice issue ହେଲା ପରେ I can't convert it.
ସାର୍ ଆଉ ଦିନକୁ
ସେ ଆସିଲା ପରେ ଆପଣ ସେ ପ୍ଲି ନେଇ ପାରନ୍ତି. Once the notice has been issued by another coordinate bench, I can't modify that order. That now I will convert it to another. ଆପଣ କଣ CRLA ହବ ଏହା କହୁଛନ୍ତି?
CRL
could be ସେଟା ଆପଣଙ୍କ
372 ରେ
ସେଇଟା ପ୍ରୋଭାଇଜରରେ ସେଟା ଏଠି ଷ୍ଟାଫ ରିପୋର୍ଟିଂ ବହୁତ ଆଜି ଗୁଡେ ମ୍ୟାଟର ଲିଷ୍ଟ ହେଇଛି ସେମିତି ଆପଣଙ୍କର ସେମିତି ନାହିଁ ନୋଟିଂ
ନା ମୋର କଲେନି ବେଲେ ମୁଁ କାଲି ବହି ଦେଖିଲି ମୁଁ ଜାଣିଲି ଯେ ଏଟା ଭୁଲରେ ହେଇଯାଇଛି CRLLP
ଭୁଲଟା ତ ଆପଣ କରିଥିବେ ନା
ହଁ,
ଆପଣ
ସାର୍,
ତ
ମୁଁ
ପିଟିସନର ତେଣୁ ସେଟା ସିଏ କାଇଁ କରିବେ ବୋଲି କହୁଛନ୍ତି?
ନାଇଁ ମୁଁ ଭୁଲ କରିଛି ସାର୍
ନାଇଁ ନାଇଁ ହ୍ୱାଟ ଏଭର ନାଇଁ ସେଟା ମୁଁ ଭୁଲ ଠିକ ବୋଲି କହୁନି ସେ ଆପଣ ନୋଟିସ ଯଦି ସଫିସିଏଣ୍ଟ ହେଇନି ଆପଣ ଡିସାଇଡ କରନ୍ତୁ କଣ
ମୁଁ ଆଉ ଗୋଟେ ଥର ନୋଟିସ ନେବି
the office note put up by the registry Namita Patnaik for the petitioner opposite party blank office note put up by the registry dated 16/11/2023 indicates that neither AD nor unserved notice has been returned from the sole opposite party till date. Limitation notice pursuant to order dated 19/2/2020. The learned counsel for the petitioner seeks accommodation to take notice afresh in the present correct address. Prayer is allowed. Let notice be issued afresh in the present correct address by registered post with AD. How much time? 3 weeks, 2 weeks. Kebe ket din nebe?
7 days 2 weeks
Within 2 weeks. Yes.
67
67, if I know the name of the counsel appearing for the opposite party, I'll serve the copy. The noting is that copy not served. Or else OSH may permit me to take notice marks in the matter limitation.
In the case brief, they have not indicated. Let me check, and they have indicated in the
Name of the lawyers. This noting indicates copy not served. If somebody appears not served,
that's a mistake by the.
Then Lordship may permit me to take notice by registry post.
Defects. Whether defects removed or not, that has not also not been indicated.
No, this is a case of 2018. I'll take notice marks.
Here they have put that stamp of the deputy registrar non-appears defects as pointed by the stamp reporter be removed within 1 week. But what are the defects they have not indicated?
But today is listed for consideration of for condemnation of delay. Let notice go in that
IA Lekhantu 15/2021. The application has been filed for condoning the delay of 301 days in filing the CRLLP. Sapara had learned standing counsel for the petitioner issue notice to the sole opposite party by registered post with AD. Requisites for issuance of notice be filed within 3 weeks.
3 weeks, no?
In 3 weeks in present correct address. List after SR.
68
Mr. Manish Dhir on behalf of Sarthak Naik for the petitioner. The learned counsel for the petitioner seeks opposite party blank, seeks accommodation to remove the defects as pointed by the SR. As paid for, further 3 weeks time granted to remove the defects. Yes.
69
Let notice go, my lords.
IA 57/2018. The IA has application has been filed for condoning the delay of 106 days in filing the petition. Had learned standing counsel for the state issue notice to the sole opposite party by registered post with AD. Requisites for issuance of notice be filed within 3 weeks. list after SR.
Your Lordship, in 116 days, my lords.
106. 106 days. Yes. 70.
70.
Mr. Das.
70, my lord.
Defect certified copy not filed.
Yes, my lord.
Mr. Parthasarathi Das for the petitioner. Mr. Opposite party blank. The learned counsel for the you don't have instructions or what?
Yeah, yes.
The learned counsel for the petitioner submits that due to inadvertence, certified copy of the impugned judgment has not been filed, and he may be granted further time to obtain the same as well as up-to-date instructions from the petitioner as prayed for the 3 weeks time. 3 weeks time granted.
After 1
week ପରେ ଆଉ ଥରେ ସବୁ ଯାକ list ହେଇଯିବ ଫେର defect.
1 month.
4 weeks time.
Yes.
4 weeks time.
The 71 to 74, all pertain to 2018 and 19. Let notice go in all the cases. I'll file the requisites.
71 IA notice for same order कर देबे. But delay period ta vary करियो.
71 days.
3 weeks time or 4 weeks time?
3 weeks time in all.
3 weeks time.
72.
Same order.
Same order.
73.
Same order.
74.
Same.
आपण से कॉपी नॉट सर्व फ्रेश मैटर रे कोन लिखचंती जोथरे स्टेट पिटिशनर अछि से कॉपी कोन सर्व करिवे
Maybe in,
actually they are thinking that since state is a party so but state is a petitioner here.
Let's may know the fact
Delay.
the fact of delay.
Okay, so we have to go by case by case.
71.
71. ଆଜ୍ଞା ମିଳିବ 36 days.
Minors.
72. This is 18. 105. 105 ଦିନ.
73.
78 days delay.
78 days.
$271.
271.
74. So Tripathi, you have paid. Already paid today. We filed it in the registry. The Mr. Amitabh Tripathi for the petitioner, opposite party blank, the learned counsel for the petitioner submits that the deficit fee of rupees, this is authentication fee. The authentication fee of rupees 7, 15 paise has been paid. The memo of filing the fee shall be, the receipt memo shall be filed in the registry. The registry shall do the needful.
Next week.
କେବେ ଆସିପାରିବ ଏଟା?
Press ratio, press admission.
28 list on 28/12. But here 23 matter it will not come. Now you see the press matter is coming because that serial serial I mean the appropriate number and here it cannot be changed. So computer shall joti padibo seti asibo. But it may come on Monday also.
No, fresh admission.
List for fresh admission after removal of defects. Yes.
76.
Some other day, Mr. Mahapatra is personal difficulty. Some next week.
Mr. S.S. Mahapatra, ASC for state. Mr. Prabhas Chandra Panda for the opposite party number 1, 3, and 4. Learned counsel for the petitioner 6 accommodation. He has some difficulty, Mr. Panda. When do you want?
Next week.
Yes, Mr. Panda. As prayed for list on 29/12. I'm sorry, 29/11. Tuesday.
77,
Same thing, same plan, my lords.
77, Mr. S.S. Mahapatra AC for the petitioner. Opposite party, anyone appearing? Opposite party blank. Opposite party non kar diyantu. The learned counsel for the petitioner seeks accommodation as prayed for. List on 6th of
$78.
I am for the opposite party, my lord. This is against the order of acquittal. 15 years back, order of acquittal has been passed, and there is no infirmity in the order, my lord. Lord court below has categorically stated.
Sorry, it was switched off.
My
So since everyone, I'm giving chance, at least 1-2 chance, so let us
Yes,
wait
ma'am. Yes,
to grant further opportunity. List on 7 ता पर week रे रखना ता आसीबेनी 15-12 7 बार तो ठीक है 7 बार. Yes. Next, please.
79.
79, Lordship. I am for the opposite party.
See, they have taken time.
CBI matter.
They have taken time.
Lordship.
Mr. Manish Dhir on behalf of Sarthak Naik for the petitioner. Here, delay, it is ready. It is
Delay
after notice admission matter.
Lordship, delay. No.
Mr. Miss M.S. Anima Kumari Dei for the opposite party. The learned counsel for the petitioner seeks accommodation as paid for. List on 5th of January 2024. Name of Mr. Sarthak Naik be indicated in the cause list as well as the case brief for the petitioner.
December.
Copy of the petition be served on the copy of the CRLLP along with annexes be served on the learned counsel for the opposite party. Yes, next.
80.
May it please, my lords. My lords, this,
Devasis Naik for the state, AGA for the state. You are there.
my lords.
Yes, please.
This is a leave to appeal directed against the judgment dated 10/12/2007
Yes.
of the learned second additional sessions judge Barampur.
Yes.
The accused was facing trial under sections 498A, 30B, 304B, 306 IPC, and
Yes.
section 4 Dowry Provision Act.
Yes.
My lords, may kindly come to internal page 6, paragraph 8 of the
Yes.
judgment. And I've gone through the deposition copies also. They're
Yes.
available on record.
Yes.
To be fair, I did not find anything perverse there. So those findings are there in paragraphs 8, 9, and 11. 11 is summing up, but 8 and 9 are the material paragraphs.
Yes.
May I please?
It may not be required because since you have already verified, so
My lords,
there is no point in deliberating over that.
My lords.
Suppose if you find out anything, then you place it, then
My
it requires further deliberation here. Mr. Devasis Naik, the learned counsel for the petitioner had the CRLLP has been filed under section 378 into bracket 1 and 3 of the CRPC, seeking leave to appeal against the order dated 22/4/2008 passed by the second additional sessions judge Barampur in sessions case number 13 of 2007 arising out of Barampur Mahila PS case number 33 of 2006. The learned AG appearing for the state submits that this is a fit case where leave should be granted as the learned court in the learned trial court has not taken note of the evidence on record and it suffers from perversity due to non-consideration of the material on record. Having heard the learned AGA, this court has the occasion to go through the judgment as annexed to the petition. It is fairly stated by the learned AGA that at this stage, no further evidence cannot be considered or material cannot be taken into account while considering the merits of the judgment rendered by the learned trial court. Para तापरे लिखिबे ई सबमिशन टा परे तापरे लिखिबे जोडा पर मझरे सेडा रहि गला. On perusal of the judgment the perusal of the judgment indicates that the learned court has taken note of the depositions of the prosecution witnesses as contained in prosecution as contained no PWs you referred to para page 6. Mr. Naik, you referred to page 6.
Page 6, my lords. Paragraph 8.
8. Particular PW 7 and 8.
PW 7 and 8.
7, 8, 9 and 10.
9 and 10.
The 7 and PW 7 and 8 being the parents of the deceased. PW 9 and 10 being the brothers of the deceased. And concluded that their statements in the form of deposition did not support the case of the prosecution. And stop likhibe. Rather, comma, PW 7, 8 and 10 did not clearly state regarding nature of the dowry that was being demanded by the accused, and no other evidence whatsoever was tendered before the court for consideration. Though the learned AG has strenuously tried to make out a case for issuance of leave to appeal, in contrary opinion of this court, the present case is not fit where the leave to appeal can be granted. The petition stands disposed of. Yes.
81.
This is leave to appeal preferred against the judgment dated 28/7/2008 of the learned district from Special Judge Sundargarh.
Yes.
This charge was framed under section 20 subsection B of the NDPS Act.
Yes.
For possession of 550 grams of ganja.
Yes. 50 grams. 550 grams.
550 grams. My lords, may kindly come to para 15. Internal page 14 of the judgment.
Yes.
It is a technical offense, so this was not satisfied. And strangely, in this case, most of the raiding party that had accompanied the IO has not supported the prosecution case. So para 15 is the most material paragraph. Then my lord may kindly come to the concluding part.
Yes.
I mean, neither technical nor substantive, none of those requirements have been fulfilled. But
same order habo. But जो PW लिखले नहीं कि particular the evidence of PW 9 लिखिबे. The learned reasoning रे लिखंतु the learned trial court has given a finding that that the IO did not, the duty of the IO to forward copy of the information recorded regarding the seizure of the contraband, information regarding the contraband to his immediate superior, that is the superintendent of police. Sentence कौन लिख ले और मने रहलन. So and so to the superintendent of police has not been proved by evidence before in the trial. Therefore, a finding has been given that the section 42 into bracket 2 of the NDPS Act, being mandatory in nature, was not followed by the prosecution.
Then my lords may come to page 19, para 20. He is summed up, he has given all the points.
Para 20, my pages are torn. Become black.
Last paragraph of the judgment. Lords. May I give my brief?
Failed to comply with 42.2.
My lords.
And
Not
also
only
section 50 of the NDPS Act,
my lords,
regarding recovery, seizure and deposit of the contraband article has not been followed. Regarding recovery, seizure and deposit of the contraband has not been followed. A further finding has been given. A further finding has been given by the learned court in session of the, by the learned trial court, learned district judge Sundargarh, that section 50 of NDPS Act mandating a particular procedure regarding recovery, seizure and deposit of the contraband article have not been followed as per the evidence tendered by the prosecution. Then, though it is strenuously argued, said a conclusion to saman. Yes. Yes, you are Mr. Naik.
DK Mahapatra.
Mr. You are the same name as DK Mahapatra. I thought the senior Mr. DK Mahapatra was appearing for vigilance.
Much more senior than me.
He is much more senior than you. Yes, Mr. Dhirendra Kumar Mahapatra for the opposite party. Appearance. Yes, what do you say? Anything else to add?
Just today morning, I just
last of anyway.
Because my submission from the appeal memo is this, that section 42 is not applicable. Why? Because
so that you have strenuously argued, and so that I have already recorded. That though the learned AG has strenuously argued for grant of leave to appeal for a selection. That's last parallel lecture. Why do you say 42 is not applicable?
Because the ground taken here is that the seizure was made outside the house from a public place, for which there is no requirement of 42. So the deposition is clear that he was not outside.
But that has to come out of deposition again.
Exactly. So the deposition, in fact, places everybody inside the house.
So then that has to again. So that the learned court has done the right thing, that he said that they did not present evidence as far as compliance with 42 and 50 is concerned.
The official witnesses themselves have not supported
the prosecution case. Yes. 82. Petitioner none. Opposite party, Mr. Devasis Naik. 82. You are appearing, Mr. Naik.
My lords.
Devasis Naik, AGA for the state. None appears for the petitioner when the matter is called. To grant further opportunity, list on 4th of January 2024.
83.
Petitioner none. Opposite party none. He's from Portugal or Goa. Mauel Anunciao, opposite party. Portugal. At present at Dumduma, Bhubaneswar. This is against the order of acquittal. They are not coming. To grant another opportunity, list on. Because none for the petitioner. To grant opportunity, list on. 20th December 2023. Yes, next.
84.
Mr. Bhuya. Petitioner none. To grant further opportunity, list on.
I'm appealing for opposite party.
I think he was there, but I don't know why he has left now. Yes. He mentioned something, but Mr. G.N. Polida, petitioner, Mr. G.N. Polida for the, this is for the opposite party. G.N. Polida on behalf of A. Misra for the opposite party. By order dated 10/10/2023, the petitioner had the learned counsel for the petitioner was granted time to obtain up-to-date instructions. None appears for the petitioner when the matter is called. List on 21/12/2023 to grant further opportunity to the petitioner. Yes, next. Sub item sitare sir kichi order khabar darkar nahi because that's a connected. Yes.
85.
My lord, on behalf of Mr. V.S. Das, it's kindly take up 2 weeks.
Apno last time bhi time nahi thile. Mr. Apno ka naata?
Devaki Marandi.
Miss D. Marandi on behalf of B.S. Das for the petitioner, opposite party blank. The learned counsel for the petitioner seeks accommodation. As prayed for, list on 5th of January.
86.
Petitioner none. Opposite party, Mr. Standing Counsel for the state. None appears for the petitioner when the matter is called. To grant further opportunity, list on 3rd January 2024.
87.
May I please also?
Yes.
The order of acquittal, 138 NI Act.
Yes.
The only point to be decided, the notice sent on 3/4/2012, and it is alleged that 9/4/2012 to 16/4/2012, the accused is absent. But the court below calculated the date from 16/4. And
para 8 ta padontu. Para 8 internal page, running page 10.
My lord.
Para 8 ta padontu.
Now let me examine how far the complainant has proved.
Slowly padontu. Slowly padontu. Go slowly so that,
my lord,
yes, don't miss anything.
Now let me examine how far the complainant has proved her case against the present accused beyond all reasonable doubt. On perusal of the evidence available on record, it reveals that the complainant deposited the alleged check bearing serial number such and such for amount 22,000.
Dated 23/1/2012.
My lord, 23/1/12. For amount of rupees 22,000, and the check bearing serial number such and such dated 12/2/2012 for amount of rupees 30,000 before her bank, that is SBI Raj Sunakhala branch for encashment, but those were dishonored due to insufficient funds, and the same was communicated to her through the bank return memo on 26/3/2012. Further, there is a great confusion public doubt came to notice regarding the date of presentation of the erased check in the bank, the date of decision of those checks and the intimation made by the complainants bank as a bank seal on the exhibit 1 and 2 clearly shows it to be on 27th March 2012. And the intimation of the bank exhibit 3 as well as the contents of the legal notice exhibit 4 shows the date of issuance of the exhibit 3, that is 26/3/2012. Besides that, which is the findings of the learned court below, that as per the complainant's case, the legal notice written answer on her on 16/4/2012 with endorsement as address is absent from 9/4/2012 to 16/4/2012. And in view of the statutory provisions laid down under section 138C of the NI Act, the cause of action to file a case arose after the completion of the 15th day of thereof, that is 2/5/2012. So it is very much clear that the case has been filed prematurely. It has been decided by the Honorable Apex Court of India as well as by the Honorable High Court of Orissa in so many reported cases that the provisions of the NI Act need to be strictly followed with regard to the compliance of all statutory aspects, and deviation of any of the said statutory requirements will not make out of accused liable, especially under section the NI Act. Now, my respectful submission before your Lordship is the 9/4, if the cause of action arise, and 15 days thereafter, I file the 1CG case.
9/4 केमती लगे?
आया से दिन टू एब्सेंट है ना से?
नहीं नहीं
आया हाँ लिखा है 9/4/2012 टू
अरे आपण 16 रे पाइले आपण केमती 9/4 पछुआ कर देबे ताको आपण डेट टा मिस करूचंदी
ना मु सेरा पाइले 16 डेज
हां सो आपण 16 रे जो पाइले तार 15 दिन भीतर आपण एटा कोठी को सेक्शन रे एटा अछि
138C
हां देखु नांदी एटा तो स्टैट्यूटरी प्रोविजन एतरे कोन असुविधा अछि एमती पछो घुंचेले देयर इज नो एंड टू इट देन
मु को 9/4 रु 15 दिन हेले मु 27/4 फाइल कर
9/4 रे केमती हिसाब करी आपण तो आपनकर केस होची 16/4 अच्छा रावण सुनतो आज्ञा
आज्ञा
आपण डिजनर केबे हला डेट पडिची बैंक केबे डेट दैचंती
26/3/2012
26/3
मु
आपनकर नाही नाही नाही
3/4 रे
27/4 रे 27/3 रे
नाही 27/3 जे हला परे मु नोटिस देची 3/4/2012 रे माने विदिन 15 डेज माने स्टिपुलेटेड पीरियड रे तो फाइनल आपण 16/4 रे पाइछन ना पाइ नांती पाइछि
तल पाइले तो सरला कोन 138 कोड सेडा क्लियर आपण पाउछ
9/4 रु मु नोटिस देली 3/4 रे 3/4 नोटिस देला परे माय रेस्पेक्टिव सबमिशन बिफोर लॉर्डशिप इज जेहेतु 9/4 रु एब्सेंट हला 9/4 रु 15 दिन हिसाब कर देली
सेटा सेमती
आ मु 27/4 रे फाइल कर
सुप्रीम कोर्ट रे ही पारे हाई कोर्ट रे हबन
27/4 मु केस फाइल करिछि
आपण क्लियर 15 दिन तो देलेनी आ
9 देले
16 रु 15 आपनकर 16 रु 15 हेले आपनकर एक्चुअली सेटा पळेबो से ठीक हिसाब करछन 2/5
नोटिस देछि 3/4 रे
आपण 16/4 रो 15 दिन परे आपण दबा कथा फाइल करिया कथा 2/5 होची ठीक अछि हिसाब ठीक अछि
नहीं 3/4
आपण 16/4 डिस्प्यूट करू नांती किंतु आपण 16/4 रे 9/4 कहउचंदी कायना से 9/4 एब्सेंट थिला 16/4 पूर्वरु से कोन आपण जेबे पाइले ता पूर्वरु कोन था दैट्स नॉट रेलेवेंट आल्सो आपण 138C पढंतु आपण कोठरु से डेट आणुचंदी कहू नांती
ए जो फ्रॉम द जजमेंट
हम जजमेंट नाही आपणकर डेट ता कोठ आणुचंदी
आज्ञा
that it can be shifted backward 7 days हे जिवो सेटा आपण कोठ आणुचंदी
ना एरा लेखा जजमेंट पर
आपण कहउचंदी दैट इज योर सबमिशन
हां नहीं लेखा जजमेंट
सो सेटा को प्रोविजन ने आपण करि पा 7 days ताको पछुआ करियो
जो नॉर्मल एनआई एक्ट जो अछि
हां कोड देखु नांती सेटा आपण एम्ति करिया रे कोन अछि आपण बही रे देखिबे आपण नॉर्मल एनआई एक्ट कोन स्टेट कम टू दैट प्रोविजन
मारो
ना बही नाही
बही ना
तो नो नांती हमर आउ एनआई एक्ट नहीं ओके कोटे अछि
130C may I read my lord
पढु नांती
the drawer of such checks fails to make the payment of the said amount of the money to the payee or as such the case may be to the holder of the due course of the check within 30 days of the receipt of the said notice
15 days na provided that nothing contained in this
138C
section
जो
shall
लिखिଛନ୍ତି,
apply. ସେ ଯୋଉ ଅଛି
ମାଲ।
proviso ଟା ଅଛି,
ଆଜ୍ଞା।
nothing shall apply if so and so condition is not fulfilled.
3-4 ରେ ଦିଆହେଲା ନୋଟିସ ଟା 3-4 ପରେ 9-4 ଯେହେତୁ ସେ absent ରହିଲା
ସେ absent ରହିଲେ କି ତପସ୍ୟା କଲେ, how the court can go into that? What is the relevance of that? ସେ କଣ କରୁଥିଲେ? The relevance, ଶୁଣନ୍ତୁ ଆପଣ ଏଟାକୁ dilute କରିଦଉଛନ୍ତି actually.
dilute କରୁନି।
No, Mr. No, Budhya, no. This will set a bad precedent. Once that is diluted, then other claimants will face difficulty.
No,
ଶୁଣନ୍ତୁ ଆପଣଙ୍କର, you see there is a problem. Suppose that what would be the consequence of such interpretation?
What is
the consequence would be that suppose somebody files exactly after 15 days, it will be a plea for the debtor to say that no, I was absent, I was sleeping, I have gone for pilgrimage. So those things are not relevant as far as this C is concerned.
As per the statute is concerned, from the date of the receipt of the notice, not that when the date on which we received the AD. Here in this case, on 16/4,
you see the problem is that on 16th you come to aware that he is absent.
My lord.
So from when he is absent, that is not at all relevant.
My lord, when we receive the AD, that is not the law. Law is from the.
Sir, सेटा आपण orally कुहंतुनी. Either you cite a decision or आपण बर्तन खाली कहले 138 रे अछि. 138C is very clear. It doesn't say what happened prior to that. 16th रे आपण जो दिन पाइले तार 15 दिन भितर से फेल कला. आपण 15 दिन न देके आपण ता आगुरु कर देले 27th रे कर देले.
किंतु जदी from the date of the receipt of the notice जदी हुए, then it comes to 9 is into force.
No.
क्या आमे जो दिन एडी पाउचु से दिन 15 दिन हिसाब होनी. जो दिन से नोटिस पाउचंदी से दिन 15 दिन हिसाब होची.
से तो पाई ना देता.
हां, that is पाई
ना दी. So से एस्पेक्ट को गले नहीं.
किंतु
सुनंतु
that is not reflected in the judgment कि से पाई ना दी बोले.
नोटिस पाई ना दी, से नोटिस पाई ना दी तो सेटा आ गोटे पार्ट सेटा सी चैलेंज करबा कथा.
That is correct. That is another part.
से चैलेंज करिवे. से जदी सेटा को कॉग्निजेंस नहीं थांते कोर्ट जे द केस इज मेड आउट, देन से कहता ना कि हम नोटिस पाइने.
So merit after
merit actually the defendant has a better case, but since they have not gone there, so I am not going there also.
They adduce the evidence. After evidence,
you have not received. They have not received notice. That is the finding of the court. They have not received notice. That is the finding of the court.
Because they adduce evidence. Examine and cross-examine.
It is not a question of आपण कोन तापरे करिवे. ये what is that called? By conduct. But what is that called? This acquiescence by conduct. एतरे criminal law रे सेटा applicable no.
एना जो दिन ठू से रिसीव करूछंती से दिन 15 दिन
से नोटिस पाइ नांती. It has been returned.
But on that ground
15 दिन भितरे जदी ताको assume करा गला sufficient बोली ताहाले 15 दिन रे आपण दबा कथा. Assume करी कि that it is sufficient 15 दिन हबो 2-5 रे.
But on that ground it is not acquittal.
No, it's not a good case, Mr. Budhya. This is item
87.
Mr. 87, Mr. Arun Kumar Budhya for the petition.
Earlier, Lordship issued notice to the respondent. And
opposite party, so M.S.Sahoo is appearing. Opposite party none. The same order like the CRL LP, the petition has been filed under section so and so of the CRPC, challenging the order dated so and so, passed by so and so. The Lord Counsel for the petitioner strenuously argued that the judgment incorrectly in its judgment, the learned court of the STJM Khordha appreciated the implications of section 138C wrongly, as the date of notice should have been from 9th 15 days as 15 as 15 days should have been calculated from 9/4/2012, though the legal notice was returned unserved and received by the complainant on 16/4/2012. As it is indicated that the addressee was absent from 9/4 to 12 to 16/4/12. Therefore, 15 days are to be calculated from 9/4/12, not 16/4/12. Whereas the learned court calculated the 15th day from 16/4, making the date to be 2/5/2012, whereas the complaint was presented prior to completion of the 15 days. In considered opinion of this court, there is no error apparent or perversity in the calculation of the 15 days, which should in fact be from 16/4/2012. It has also come to the notice of this court that the opposite party was not served with the notice as per the finding of the court, though the said aspect has not been dealt with. Having heard the learned counsel for the petitioner, the petition is disposed of as the case is not fit for issuance of for grant of leave to appeal.
I mentioned in para 7. I have taken a ground in para 7, page 4.
Yes. Ground of ground dekhi debe. Yes. Since no time is left, the mentioned matter would have likhi diyo.
Item 88.
Mr. Lakshman Pradhan, Mr. DP Das, Mr. DP Das for the petitioner. 88, Mr. Standing Counsel, you are there. 88, 88. Yes, Mr. Mr. S.S. Mahapatra, AC for the state. The learned counsel for the petitioner seeks accommodation. No time is left for any further hearing of the matter. No time is left today for hearing of the matter. List on 4/1/2024.
89.
Mr. H.S. Misra for the petitioner. Mr. S.S. Mahapatra, AC for the state. Learned counsel for the petitioner submits that despite registered letter being sent to the petitioner, no response has yet been received. The learned additional standing counsel shall obtain up-to-date instructions from the IAC regarding welfare of the petitioner. OP4. You seek it from the IAC. From the concerned IAC to regarding regarding welfare of the opposite party. Sorry, welfare of the petitioner. Yes.
98.
Mr. DP Das for the petitioner. The learned counsel for the petitioner seeks accommodation to obtain instructions. No time is left for hearing of the matter. No time left today for hearing of the matter. List on 9th January 2024. Any other matter left mentioned to say like? Thank you.